That is your lordship. Lordship, the
Yes.
item number 38.
Item
Number 38 in the hearing list. Lordship.
38.
Lordship, this matter
Hmm.
was heard in part on 30th November 2023, though it is not reflected in the cost list, Lordship. So, Lordship, there's another part heard matter, that is item number 27. May I pray that this matter be taken up immediately after item number 27? It's a part heard matter.
27.
After 27, Lordship, kindly take up item number 38, which is another part of it.
Okay, this connected matter.
No, it's not connected, my lord. But this was also heard in part,
Okay,
though it's not reflected in the cost list.
let us see. Okay.
All right.
May I please, my lordship, my lord, I beg to mention item number 25.
There is ecosystem, I think. Item
Item number 25. My lord, here I'm yet to receive instruction. So, kindly allow me to fix. I'm yet to receive instruction, my lord.
20.
25.
Fine.
Yes.
Mr.
E-tip form for the state respondent.
Okay. So who is for the petitioner here?
Lordship, I'm for a petition.
So he has to receive instruction. Any objection?
No objection, lordship.
So for
Lordship,
when do you
however,
want?
with 3 weeks time, my lord.
Mr. Yes, you are Mr.
Ali Bol, lordship.
Counsel and Mr. And counsel for the respondent. The learned counsel who submits that he is yet to receive instruction and prays for listing this matter after 3 weeks.
Yes, lordship, there is interim. Interim may be continued.
Okay. The prayer is allowed. List this matter after 3 weeks. Stop. The interim order passed earlier shall continue till the next stage. Okay.
Right.
Ready for?
34 and 35. Your Lordship, let the matter come up after 4 weeks, Your Lordship.
You have any objection?
No objections, Your Lordship.
Okay. Miss. Learned counsel for the petitioner and Miss. You are for respondent
For the state respondent.
for state respondent who prays for listing this matter after
4 weeks, Your
4 weeks. The prayer so made has not been objected to by the learned counsel for the petitioner. Accordingly, the prayer is allowed. List this matter after 4 weeks. Okay.
Your Lordship, I also beg to mention item number 36, Your Lordship. 36.
36.
Your Lordship, let it come next week, Your Lordship.
Okay. You're for the petitioner. Okay. Miss. Learned counsel for the state respondent prays for listing this matter after a week. to which Mr.
Lordship,
No, your good name.
I'm appearing on behalf of my senior lordship,
Okay. You are Mr.
Ali Balsakam lordship,
appearing on behalf of
CD Jamil.
citizen. Counsel for the petitioner has no objection. So accordingly, the prayer is allowed. List this matter after a week. Okay.
Your Lordship, I also beg to mention, admission item number 17, Your Lordship. 17. Your Lordship, 2 weeks will be granted for compliance, Your Lordship.
Lordship, I put a petition.
Okay. Mr. Lima Pangnas?
Yes, lordship.
No. Yes, learned counsel for the petitioner. Stop. Miss learned counsel for the respondent prays for another 3 weeks for compliance of the direction. The prayer is allowed. List this matter after 3 weeks. Okay.
Which of like?
May please Lordship, Lordship, I beg to mention item number 8.
Yes. Yes.
Lordship, here, the matter relates to payment of minimum scale of pay.
Yes.
And the government, we have constituted a committee on 16 February, Your Lordship, to look into the matter. But after the constitution of the committee, the model code of conduct has been enforced for election. So the committee could not set, Your Lordship. So I pray that 4 weeks' time may be granted, Your Lordship.
Okay. So who is for the petitioner?
So, Your Lordship, item number 8, 16, and 22. These are minimum scale of pay.
Similar.
Yes, 8, 16, and 22, Your Lordship.
So, Ms. V. Sukri, learned counsel for the respondent, submits that although committee was constituted for examination,
Yes, Lordship.
committee constitutes for what?
Committee, here, number A, Your Lordship, terms of reference for the committee to examine the existing legislation and the Supreme Court
Which were
directive.
Constituted to examine
The existing legislation.
the existing legislation
Yes, and the Supreme Court directive with regard to pay parity,
and the Supreme Court directive
with regard to pay parity.
with regard to pay parity.
Yes,
However, due to the
model code of conduct.
due to the imposition of the model code of conduct for ensuing election, the same could not be materialized.
Yes, they could not meet, Your Lordship.
The committee could not meet.
Yes.
Accordingly, prays for
4 weeks, Your
4 weeks'
Lordship.
time. Stop. Mr.
Elikas Singh, my lord.
And counsel for the petitioner is also present. Is present. Stop. In view of the above, list this matter after 4 weeks.
Okay, much obliged. Lordship, again, item number 13, 1-3.
Yes.
Lordship, here, the Advocate General,
Hmm.
he has seized of the matter to file an SLP before the Supreme Court. So the matter is under preparation. So, Your Lordship, I pray that 4 weeks' time may be granted.
Okay. Who is here? For the petitioner? No.
They have to-
Ms. Sukri. V. Sukri, Land Council for the respondent prays for submits that the AG
Yes. Advocate
Yes.
General.
preparing or already preferred SLP.
He is under preparation because I personally went to Delhi and met him, Your
Okay.
Lordship. Yes.
So, an SLP is under preparation
Yes, Your Lordship.
to challenge the impugn
Yes.
order, judgment and order. Passed, but it was passed by single bench.
Yes, it was passed by the single bench against which the state preferred the appeal before the division bench. But
Okay.
the appeal was dismissed, Your Lordship.
Okay, and in view of the above, pray for
4 weeks' time, Your
4
Lordship.
weeks' time. Okay, The prayer is allowed and none appears on behalf of the petitioner. The prayer is allowed. List this matter after 4 weeks. Okay,
Lordship, again, item number 23.
yes.
Lordship, here, kindly grant 4 weeks' time to file affidavit for respondent number 7.
So, any,
No objection.
Mr.
Sentilo.
Counsel for the petitioner is present. Stop. Ms. V. Sukri, counsel for the respondent number 7.
Lordship, I'm appearing for respondent 2 to
2 to
6.
Praise for
No, 2 to 6.
4 weeks time to file affidavit.
Affidavit, 4 weeks, Your Lordship.
Okay, the prayer is allowed. List this matter after 4 weeks. Okay.
Much obliged.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 15. If 3 weeks' time can kindly be granted, your lordship, to obtain the necessary instruction, my lord. After
Yeah, for
15, I
this-
have taken the consent of the other side, my lord.
Okay. So, Miss,
Ubang Nanalocha.
counsel for the petitioner is present. Miss Jimomi,
And Angami, my lord.
sorry, Angami. Jimomi Angami. Counsel for the respondent prays for
3 weeks' time, my lord.
3 weeks time. For file affidavit.
Obtain the necessary
To
instruction.
obtain necessary instruction from the client. The prayer is allowed. List this matter after
3 weeks, man.
3 weeks.
I am deeply obliged.
May I please, Lordship? I beg to mention item number 51 from the hearing list, my lord. My lord, it's a consensus prayer, my lord, let this matter be fixed on Thursday. That is, 25th,
It is fixed on, huh?
25th.
You want the matter to be fixed on 25th?
Yes, my lord.
Why?
Uh,
25th
yes.
of April.
Yes, my lord.
Who is for the other side?
It's a consensus prayer, my lord.
Okay. As prayed for by the Land Council for the petitioner as well as the respondent. List this matter on 25th.
Yes.
Okay.
Obliged.
Published lordship.
May I please, Lordship?
Yes.
I have a prayer for item number 18 also, my lord.
Item 18.
Yes, my lord. I'm for the respondent number 2, 3, and 4. My lord, yes, contempt. My lord, I pray that we may be given 3 weeks' time to obtain necessary instructions.
Okay. Mr.
Tushitranjan.
Okay. Land Council for the petitioner is present. Stop. Mr.
And Longkuma, my lord.
Land Council appearing on behalf of the respondent number 3 and 4. Praise for
2, 3, and 4, my lord.
3 weeks.
3 and 4.
2, 3, and 4. Prays for 3 weeks' time to obtain necessary instruction from his client to file affidavit.
Yes, my lord.
Okay, stop. The prayer is allowed. List this matter after 3 weeks. Okay.
Obliged.
Published lordship.
Yes.
My lord, I beg to mention item number 40
Hmm.
of the hearing list. My lord, if this can be listed next week.
14 is for admission.
40, 40, my lord.
40.
Yes, my lord.
Okay. Next week.
Next week, my lord.
Okay. You are for the petitioner.
My lord.
Okay. You are for respondent. Okay.
For private respondent number 4.
Okay. Mr.
Takakichu.
Land Council for the petitioner prays for listing this matter
Next week, my lord.
next week. After a week. Stop. Mr.
Elikasasangam.
Land Council for the respondent number
4.
4
Yes.
and Miss
AIME for respondent 1 to 3.
for the respondent number 1 to 3 are also present and has no objection. Accordingly, the prayer is allowed. List this matter next week. Okay.
My lord, I also beg to mention item number 9, my lord.
Yes.
My lord, here I'm mentioning on behalf of Akin, who is the counsel for the petitioner. If this can be listed on 7th of May, my lord.
Okay. Who is for the other side?
Lordship.
Okay. Mr.
Takakichu, on behalf of
Appearing,
Akin.
appearing on behalf of Mr. Akin Wisong, Land Council for the petitioner prays for
listing the matter on 7th of May.
listing the matter on 7th of May, to which Mr.
Kiangami, Lordship.
Kiangami and Ms.
Private respondent number 7, Your Honor.
Kiangami for
State respondent.
the state respondent and Ms.
Nancy.
Nancy Wakat.
For the private respondent has no objection. Accordingly, the prayer is allowed. This list is matter on 7 May. Okay.
Much obliged.
May I please, my lord? Lordship, I beg to mention item number 12.
12.
Lordship, can you grant 4 weeks time for compliance?
Okay.
No objection, Lordship.
Okay.
However, Lordship, this is a condemned matter filed in the year 2022.
Yes.
Now submission has been made that the matter is under consideration and placed before the cabinet since 2023. I don't know why it takes so long to see the cabinet and to consider the case of the petitioner and the others. Lordship, this is a case for regularization of the work
This
charge.
is also regular action.
Yes.
Mm.
Now, after filing the condemned petition, Lordship, the writ petitioner was expired and subsequently substitution application was filed by the wife. Now, the matter pertains to finalization of pension unless the service of the petitioner, writ petitioner, is regularized. Pension cannot be settled, Lordship. So there is urgency.
Okay. So, Mr. Wati Jami, Land Counsel for the petitioner. Mr. Kiangami, Land Counsel for the respondent.
Number 1, 2, and 4, Lordship.
1, 2, and
4, Lordship.
4. Praise for another 4 weeks time for compliance of the order, direction and order of the High Court. The prayer is allowed. List is matter after 4 weeks. Please ensure, because it appears that all these contempt petitions are pending
Lordship.
for the compliance only, and time and again seeking
Lordship.
for the extension of the time.
Lordship, another thing is, respondent number 4 has retired. So,
Which one?
respondent number 4.
In which case?
We sent,
In the present case?
yes. So,
I'll take necessary steps, Lordship, for employment.
Respondent number 4 retired.
Lordship, only last 31st
The officers are given changing, Lordship.
31st March.
Initially, there were only 2 respondents. Subsequently, in view of retirement and transfer, Lordship, I filed the employment application and respondent number 3 and 4 has been employed. And now that respondent number 4 has been retired, I have to file another employment application, Lordship. So I'll take necessary step, Lordship.
Okay, so Lana Counsel for the respondent, Mr. Hangami, informed, brought to the notice of this court that the respondent number 4, engineer Pukronizo Kera,
Engineer in chief.
engineer in chief, NPWD has retired. Has already retired on
31st March.
31st March 2024. Start. The petitioner shall take necessary steps.
Lordship, in that view of the matter, if his name may be struck off from the,
No, Lordship. It's a condemned.
The necessary steps to include the new incumbent.
okay.
So within
Within
2 weeks.
2 weeks, Lordship.
Okay. Okay.
Lordship, I'd also like to mention item number 38, Lordship.
38.
Lordship. Today I have some personal difficulty in this case, Lordship, so kindly list the matter after 1 week.
Okay. So you are for respondent.
Yes, for the state.
Anyone for the petitioner?
Lordship, I've been trying to locate them, but
Okay.
locate them inside the court.
Mr. Ngame, Land Counsel for the respondent, state respondent, prays for listing this matter
After 1 week, Lordship.
after a week start. The prayer is allowed. List is matter after a week accordingly. Okay.
Pleasure, Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 10.
10. Yes.
Can you grant us 3 weeks time since the correction of the petitioner's PIM is still under process.
How much time?
3 weeks time,
You are for the
petitioner,
correction of what is pending?
PIMS of the petitioner, PIMS.
Correction of,
PIMS,
PIMS.
PI, yeah, Personal
that?
Information Management System.
okay. Miss
Berta Tep,
Learning Council for the petitioner prays for
3 weeks time.
3 weeks time to make a necessary correction in what?
Petitioners,
Okay, in the petition. Acha.
petitioners PIMS.
Okay, okay. Correction is to be made in the petition.
Yes,
Petitioner,
locating the
petitioner
petitioners.
particulars.
Hmm?
Petitioner's particulars, Your Lordship, there's some
Okay.
error in the date of birth.
Okay, okay, okay. For making necessary correction in the particulars of the petition in the course title.
No, not in the course title, Your Lordship. There's an error in the date of birth, Your
Okay,
Lordship,
okay,
of the petitioner.
okay.
So the PIMS
So this
has
was
to
allowed
rectify
earlier?
that one. Yes, yes.
Whether earlier court allowed you? You are praying for the first time.
No,
No,
Lordship.
Earlier it was allowed.
Yes.
Yes,
Okay, the prayer is allowed. List this matter after
3 weeks.
3 weeks. Miss, okay, her name also. You are for respondent number?
Yes, for the contemner, Your Lordship, for all the contemner.
Okay, present, okay.
Lordship, I beg your indulgence, Lordship. I have made a mistake. The item I mentioned as 38 is not 38, it should be 37, Lordship.
It's 37.
Yes. I'm sorry, Lordship. I pray for a week time.
Okay, so can you change it? So in 37, the
37.
Saint Younger is not present.
Lordship.
Please, Your Worship.
Yes, yes.
Your Worship, I beg to mention item number 42 and 43, Your Worship, in the hearing notes. Your Worship, the leading counsel is indisposed, so I pray that this matter may be listed in the first week of May, Your Worship.
Make appeal. You are for respondent. Right.
Respondent number 2.
For the claimant respondent. One.
Okay, you are for Oriental.
Oh, appellants.
Appellant Oriental Insurance.
Yes, sir.
Okay. Mr.
Is that cool?
Learning Council for the appellant. Praise for.
To be listed on the first week of May, Your Worship.
Okay.
Worship, let it be a fixed date, 6 May.
Hmm?
6 May, fixed date.
6th May. Okay.
Okay, Your
Just heard Mr. Consensual Learning Council for the appellant, and Mr. Joseko Pote, Learning Council for respondent,
One, Lordship.
1, and
For respondent number 2 and 3.
Mr.
City rules.
Okay, for respondent number 2 is prayed for by the Learning Council for the parties. List is matter on 6th May. Okay.
Objection.
Lordship, I also beg to mention item number 45, 44 to 47.
44 and
44 to 47.
47.
44, 45, 46, and 47.
Okay.
All in reverse matters, Lordship.
Okay.
Lordship, here I'm led by Mr. Tan Shuba. He has some difficulties. So, Lordship, if the matter can come up after 4 weeks, Lordship.
Okay. So respondent is also present. Okay. No objection. Okay. Mr. Joseko Forte, Learning Council for the
Appellant, Lordship.
praise for
4 weeks' time.
4 weeks time. So for what?
Lordship, the council has some personal difficulties and his son is not keeping well.
Okay.
Due to that reason, Lordship.
Okay. Okay. To which Mr. Bharti Jamil, Learning Council for the petitioner has no objection. List.
Respondent, Lordship.
Sorry, respondent has no objection. Accordingly, the prayer is allowed. List this matter after 4 weeks.
Lordship.
Okay.
Hello, Lordship.
May I please, Your Lordship?
Yes.
Lordship, item number 49 and 50. Lordship, by the last order, this court has directed to implead the state as party respondent in both the petition. And accordingly, on 10/3/2024, I have filed IA, which has been numbered as IA 10 and IA 11 of 2024. But unfortunately, it has not been listed, Your Lordship.
Is not?
Listed today. That IA is not listed.
IA not listed. You have already filed.
Yes, Lordship.
So want the same, the IA to be listed. So what do you want now?
Lordship, I pray that this matter may be listed with along with the IA on 22nd, that is on Monday.
Okay. Mr.
I, Jamir.
Learned counsel for the petitioner submits that he has filed IA in the present petition impleading
The state
the state as a
party,
as a
party
party
respondent number 2.
respondent. However, the same has not been listed today, staff. And prays that this matter may be listed along with the IA on after
22nd,
on 22nd.
Monday.
Monday. Okay, staff. List it accordingly. List this matter on
Lordship,
Monday,
IA number may be mentioned
along
in
with
the
the
order.
IA.
IA number may be mentioned in the order. IA number 10 and 11.
You have the number.
I have the number, Lordship.
Okay.
It has been numbered.
IA, which has been numbered in the IA, numbered as
10 and 11 of 2024.
registered as 10 and 11 of 2024. Okay,
Obliged, Lordship.
yes.
Please, Your Lordship. Lordship, I beg to mention item number 7, Your Lordship. Lordship, here I am appearing for the petitioner, Lordship. Lordship, today I have some personal difficulty. So if this can come up after 2 weeks, Lordship, I have taken the consent of the opposite party, Lordship. Item number 7, Lordship.
Yes, item 7.
Yes, Lordship.
When do you want?
After 2 weeks, Lordship.
Okay. Miss
Miss Lucino for the petitioner.
Learning counsel for the petitioner prays for listing this matter after 2
2
weeks.
weeks, Lordship. Lordship, I also beg to mention item number 24, Your
Just a
Lordship.
minute, respondent is present hearing.
Lordship, V. Jimo is appearing for the state here, Lordship.
Okay, he's
I've
not
already
here.
taken, he is not here today.
Okay, the prayer is allowed. List this matter after 2 weeks. Okay,
Obliged, Lordship. Lordship, I also beg to mention item number 24.
24.
Lordship, here, in the last occasion, I was directed to take steps on respondent number 4 through Dusty, Lordship, and I have also filed my affidavit to that effect, Lordship.
Hmm.
So notice is complete, Lordship, here.
So what you want here?
Lordship, if that can be reflected in the order, and the other respondents are yet to file their counter, Lordship.
So they may appear today since you have taken steps by way of Dusty.
Yes, Lordship.
Someone may appear today. Let us wait. Let the matter be hurried.
Respond number 2
Oh,
and 3.
Respondent are also present.
Yes,
You are for
I'm for respondent number 1. State respondent
1
1.
and
for 2 and 3.
2. And you have
For-
taken steps upon?
4.
On respondent number 4, Your Lordship.
4 is present? No,
No one has appeared yet, Your
no
Lordship.
one appear.
It has-
3 weeks time maybe.
3 weeks for what?
Lordship, I have to file
Affidavit.
in opposition.
Okay. Larika, Miss
Miss Lucino for the.
Learning counsel for the petitioner submits that she has taken steps upon the respondent 4 by way of Dusty service and filed affidavit.
I filed
And
my
also filed
affidavit
affidavit to that effect.
on 26/3/24, Your Lordship.
To that effect. Oh, stop. Huh? Stop. However, no one appears on behalf of the respondent number 4. Stop. Mr. Okay. Who is for respondent number 1?
1.
Okay.
State respondent.
Learning counsel for the state respondent is present. Stop. Mr.
Lordship, Ali was for respondent number 2
For
and 3.
respondent number 2, praise for
2 and 3, Lordship.
2 weeks. How much time? 2 and 3, praise for
3 weeks, Lordship.
3 weeks time to file affidavit. Stop. Huh? Is prayed for by the learned counsel for the party. List this matter after 3 weeks. No?
Lordship. And if notice is deemed complete, Lordship, so if that can be reflected in the order, Your Lordship.
Okay. And after that 4, huh? Respondent number 2, no one appears. Huh? No, after Dusty service and then file affidavit to that effect. Huh? In view of the above, the notice is completed. Huh? However, no one appears on behalf of the respondent.
Obliged.
Yes,
May please your lordship.
yes.
Allow me to mention item 20.
Item-
I'm bring for respondent number 2, 3, 4, and 5. I may be given a week time to file my affidavit in reply.
Okay,
Your Lordship, just an interim, your Lordship.
okay.
That interim.
Mr.
Cancel, your Lordship.
Counsel for the petitioner,
petition.
stop. Mr.
Okay, Mr. Woman.
Appearing on behalf of respondent number 2, 3, 4, and 5, praise for 2 weeks.
1 week, my lord.
1 week.
Yeah.
Praise
Yeah.
for 1 week time to file affidavit in reply.
Yes, ma'am.
The prayer is allowed. List is matter after a week.
A week.
Okay.
Lordship also beg to mention item number 39, your Lordship.
Interim.
Yes, your Lordship.
Okay. The interim order passed earlier shall continue till then. Till the next date. Okay.
Lordship also beg to mention item number 39. for
39.
Hearing, your Lordship. Lordship, I pray that the matter be posted after 2 weeks, your Lordship.
After 2 weeks.
Lordship,
Okay. No objection. Okay. Mr.
Amsolon.
Counsel for the petitioner praised for listing this matter after 2 weeks, to which Ms. Anema, Counsel for the respondent has no objection. The prayer is allowed. List this matter after 2 weeks. Okay.
May I please, your lordship? I beg to mention item number 48.
Yes.
Your lordship, my senior has some personal difficulties today. So,
There is?
Azimumi.
Ah,
Your lordship, if the matter could kindly be fixed on 25th April.
25th.
Yes, your lordship.
You have? Okay. Miss
And Solo.
Counsel for the petitioner and Miss Counsel for the respondents is prayed for by the Counsel for the party. List this matter on
25th April.
25th April.
Your lordship, there's an interim.
Oh, stop. The interim order passed earlier shall continue till the next date. Okay.
Much obliged.
May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 19, your Lordship.
Item
19, your Lordship, for the petitioner.
1
your
9.
Lordship. Lordship, I pray that a matter be listed after 2 weeks, your Lordship.
After 2 weeks.
Lordship,
You are for respondent.
Lordship, as for the respondent number 1, Lordship.
1.
Yes, Lordship.
Okay. Mr.
Amsolon.
Counsel for the petitioner prays for listing this matter. Why it is to be listed after 2 weeks?
Lordship, we're to file our affidavit, your Lordship, for withdrawal criminal petition, your
Who will you?
Lordship will be withdrawing our matter through affidavit, your Lordship.
Okay. For withdrawal.
Yes, your Lordship. We're instructed in the last interim, your Lordship. Instruction was given to withdraw the matter through affidavit, your Lordship. So,
Okay. Prays for listing this matter after 2 weeks, to which Miss
Mika.
Mika, Counsel for the respondent has no objection. The prayer is allowed. List this matter after 2 weeks. Okay.
much.
May I please, your Lordship? Lordship, I beg to mention item number 26, Lordship. Lordship, here I have an instruction to appear for the respondent, Lordship. So kindly grant me 3 weeks to file my Wakat number as well as affidavit in opposition, Lordship.
Okay. Yeah, okay.
For revisions.
Mr. Medovero, Counsel for the
Revision.
petitioner. Miss
Mika, Lordship.
Mika who appeared on behalf of respondent number?
Sole respondent, Lordship.
Okay. Sole respondent and prays for some time to file Wakalatnama. The prayer is allowed. List this matter after
3 weeks, Lordship. 3 weeks.
3 weeks. Okay. As prayed for by the land council for the parties. The respondent list this matter after 3 weeks. Huh? Okay.
Like, my Lord.
For motion, item number 1.
Please, your lordship. Lordship,
Yes.
on behalf of counsel for the petitioner, I pray that this matter may come up tomorrow. Counsel is out of session.
Lordship, I will be appearing for the Union of India and I have some serious objection in this regard. So I may be given 2 weeks time to file my objection. Because, Lordship, we have already
This is
made a
already
conversation.
not yet moved.
Yes,
Not yet moved, Lordship.
Hmm?
If this
want to
matter
file my
can
objection.
come up tomorrow, Lordship, the council is out of station.
Council is there.
Council for the petitioner, Lordship.
This is not yet been moved, not
Yes,
yet moved.
Yes,
Because,
Lord.
Let them move tomorrow,
this matter was listed on Friday also,
Yes, but
and it has not been taken up. And today is listed, and it has not been taken up.
Lordship, on the previous occasion, there was the course title, course list was, it came out only on the day of, on the very day. And due to that, many other cases were also unable to move the motion, Lordship.
So tomorrow the Learning Council will
Yes,
appear.
Lordship.
Let them move first tomorrow and then you.
Lordship,
will
not
have
for
time.
the adjournment, because it was listed on Friday,
Hmm.
it was listed today,
Hmm.
they are not taking it up.
Lordship, the
Who is
council is
appearing,
out
by
of
the way? Who is
station.
appearing, by the way,
Uh,
in this
meet
case?
your cousin, Lordship.
Let them move tomorrow.
Okay,
Mister,
Mr. K.R. Lordship.
your name is also there.
Yes, Lordship.
Okay.
But the
Learning Council-
leading council is out of station.
Okay, Learning Council for the petitioner. Submit said the leading council is out of the station and prays for listing this matter tomorrow. Stop. So your presence, okay.
It may not be recorded, Lordship,
Okay.
because it's on.
The prayer is allowed. List this matter tomorrow. Okay.
Much obliged, Lordship.
For motion, item number 2.
May I please, Lordship?
Yes.
Lordship, the matter is just pertaining to section 438 of CRPC, Lordship. More particularly 1B of 438 CRPC.
438.
Yes, Lordship. CRPC, Lordship.
So this is criminal petition.
Criminal petition, Lordship. Lordship, I'm aggrieved by the order dated 28th of March 2024, passed by the Leonard Sessions, Kohima, Lordship. Sessions Judge Kohima, Lordship.
What was the order?
Lordship, the order was, the action was given to the applicants to appear before the Leonard Sessions Judge on the date of hearing, Lordship. That the petition for anticipatory bail, it's fixed on 29th of this month, Lordship. Now, on that day, a direction was issued on considering an application filed by the Leonard PP, Lordship. Now, the PP has filed an application under section 438 1B. 1B relates to personal appearance of the applicants at the time of hearing, Lordship. Now, if your Lordship may kindly appreciate, section 148 was amended in the year 2006.
348.
438.
Yes, sir, 438.
438. It was amended in the year 2006, and this 1B was incorporated. Now, 1B, it says about personal appearance of the applicants before the
During the
sessions.
during the time
Exactly,
of hearing.
exactly, Lordship. But if Lordship may kindly appreciate, Lordship, it has also helped in the numerous cases that.
Now, what is your problem?
My
Appearing-
problem is, Lordship, 438 1B is yet to be brought into force, Lordship.
No, say for example, what is your problem appearing before the court? Any?
Lordship, I have no issue.
Okay.
However, it was considered when the 1B is not in force, Lordship.
Okay.
It is yet to be brought in force. It was also held by numerous high courts in the country, as well as the Supreme Court. Recently held in the case of Sushil Agarwal's case, Lordship, that 1B is yet to be brought in force, Lordship. So, in other words, it is non-existent, Lordship.
But why the presence of accused is required at the time of hearing the bail application?
Lordship,
He will not be asked.
actually,
So he has been, you are protected by the interim order.
Exactly, Lordship.
While the interim order already, you have already protected the interim order.
without instruction,
Okay.
the stage notice may can be issued, Lordship.
Okay.
Since this matter is pertaining to Kohima district, Lordship, a short date may be fixed. Meantime, Lordship, a record may be called for, Lordship.
So when the FIR was filed?
FIR in the year 2023, Lordship.
23.
Yes, Lordship. And
By which, when you were given, granted interim
interim on 19 December 2023, Lordship.
23.
Yes,
So
Lordship.
now the case is still under
It's
investigation.
extended
not
from
yet-
time to time, Lordship. It was fixed
No,
for
the case is still under investigation.
Lordship. Yes, Lordship. It's still under investigation, Lordship.
Have you appeared before the police? IO,
Exactly. Yes, I have appeared, Lordship.
IO has already recorded your.
Yes, Lordship. I have, the IO has recorded my statement. I was released by executing BR bond, Lordship.
Okay.
In terms of the condition laid down by the London Sessions, Lordship.
You were arrested and released also.
Exactly, Lordship. Exactly.
Okay.
And my
Then
statements
I
were
think
recorded,
this
Lordship.
appearance may not be required.
Exactly, Lordship. That is the case.
So where, have you annexed that?
The order is there,
By
Lordship,
which?
very
But
much
no,
there,
no,
Lordship.
the annexed, by which? Or the execution of the bail bond, etc. Have you annexed all those?
Lordship, the court has
Sure.
observed, Lordship. If Lordship may kindly come to this page 63, Lordship. 63, Lordship.
Yes,
If your Lordship got it. This is order dated 2nd of Feb 2024, Lordship.
yes.
The operative portion starts from it is submitted by the learned counsel that the petitioner accused persons complied with the order dated 19/12/23. That was the date of interim, Lordship, and appeared before the IO on 31st Jan, 10th of January, and 29th of Jan, Lordship. They are all together 6 accused persons, Lordship. They appeared on different occasions, Lordship. And the accused petitioner's statement have been recorded by IO, and they have recorded by the IO, and they have cooperated with the investigating agency. Therefore, prayed to regularize the anticipatory bail granted to the accused persons. Letter PP is so and so that another opportunity be given to the prosecution to coordinate to the IO and produce CD and fix another date for hearing on regularization of PRS bail granted to the accused petitioner. And in the meantime, has no objection if the pre-arrest bail granted to the accused is extended, Lordship. Clearly been observed, Lordship. And even on the next occasion, it was fixed on 28th of February 2024. The PP has sought again more time, Lordship.
The next time, the next date is
Next is 28th of March, Lordship. And it is
March
fixed on 29
29 of
February,
April.
April, Lordship. 29 April, Lordship.
So on 29, you were directed to appear.
Yes, Lordship. Lordship will find this order on page 66, Lordship. Page 66. This is the Bune order, Lordship.
Operative portion.
Operative portion, Lordship, at the bottom, if your Lordship may kindly read. The prayer of PP requiring the presence of the petitioners on the date of hearing is hereby allowed in the interest of justice. This is just the observation, Lordship. The accused petitioners shall appear before the court on the date of final hearing. The learned counsel shall also ensure the presence of their petitioners on the date of final hearing. The pre-arrest bail granted to the accused petitioners extended for another 30 days on the same
This
terms
is
and
contrary.
conditions.
Pre-arrest bail extended and why his appearance is required? This is for the bail application only, not for any,
Yes, Lordship.
because charge is not yet filed. Mr.
More Jamil, Lordship.
Moazami, counsel for the petitioner. Para. And also Mr. K. Angami, Land Council, Planet, additional PP, State of Nagaland, staff, Para. Crossing of which order, the
28
just you have read.
March 2024. Yes, Lordship, that order, Lordship, which I have just referred to, Lordship.
Okay.
Page 66.
This is an application under section 482, read with section 397, praying for quashing and setting aside of the order dated 28/3/2024, passed by the learned Principal Session Judge, Kohima, Nagaland, in IA number 341, 2023, by which the applicant
Yes, Lordship.
is directed to be present on
29/4/2024.
29/4/2024. for final bail hearing. Stop. Record is necessary?
Maybe lordship, scan copy maybe.
Okay. Call for the scanned copy of the record. Start. Issue notice, returnable by 4 weeks. Stop. Since Mr. Angami planted additional PP, accepted notice on behalf of the state respondent. No formal notice required to be issued. However, have you received the copy?
Lordship, actually, my Leonard, my colleague is supposed to handle the matter, but he's indisposed today. So,
Okay.
we have received, but personally, I have not seen it yet.
Okay.
Lordship, I can also serve extra copies, Lordship.
Hmm?
I can also serve extra copy of
Okay.
the petition.
You accept extra copy? Okay.
Lordship.
However, the petitioner shall furnish extra copy of the petition to Mr. Angami during the course of the days. Stop. List this matter after 4 weeks.
Lordship, sorry for indulgence, Lordship.
In the meantime,
If this matter is listed after 4 weeks, if my interim prayer may be considered, Lordship.
In the meantime, just a minute, sir. The appearance of the where was the impugn order? Page
66, Lordship.
six. Okay.
66, Lordship. Order
that
dated
means-
28/3/2024, Lordship.
Okay, just a minute, sir. In the meantime, since the accused has already protected by the interim order and his interim anticipated bail has already been extended by the same order by the learned special judge. This is NDPS.
No, Lordship, it is not interface matter.
Hmm?
No, Lordship.
It was passed by special judge NDPS Kohima.
Lordship, this must be wrongly reflected, Lordship. Otherwise, this is not an NDPS matter, Lordship.
Not NDPS.
Yes, Lordship. It's not NDPS, Lordship.
Okay. Till the returnable date, the appearance of the accused before the said court in connection with the bail application shall is dispensed with.
Lordship.
Okay.
Lordship, another aspect, Lordship. There are altogether 7 accused persons.
How many you have, this is application
This
for
is
how many?
for six persons, Lordship.
All 6 persons.
No, only for 6 applicants.
All of them are protected by the interim order.
Yes, Lordship. All of them are protected.
Have you annexed all of them?
Lordship, all the orders are there, Lordship.
Okay.
Altogether 4 orders are there.
Lordship, as far as the interim concerned, if I'm sorry to indulge, you seek your indulgence, but if it can be heard again, because
Yes, I thought it's only one.
yes,
Maybe, by the same order, only by one order, all of them are being protected.
Yes, Lordship. All the 7 persons.
Where?
Lordship, the first paragraph, Lordship, which reflects all the names of the applicants, Lordship. Page 66, Lordship. Then the counsel, Mr. So appeared for the accused persons 1 to 6, Lordship, and another counsel, Lordship, representing Mr. So
Counsel,
for 1, Lordship.
2, 3, 4, 5, 6. Okay.
So this petition is pertaining to only the first 6 accused persons.
I think 417, 464, 466. Have you annexed interim bail order?
Yes, Lordship.
Where?
Yes, Lordship. Page 57, Lordship.
Where,
57.
let us see the condition imposed upon them.
The operative portion, Lordship, will find the conditions at page 61, Lordship.
Shall appear before the eye of the case within 45 days as and when called. As and when called for. You see, IO can call anytime. Under the circumstances, I think their appearance for the bail hearing is not required. Now also IO can call him anytime, but then why the court required them? It is still under investigation stage.
Lordship, with
Okay.
due respect, Lordship,
Hmm.
the learned sessions considered only on the application forwarded by filed by the PP, Lordship. Otherwise, the learned judge has not discussed about the reasons why their presence is required, Lordship.
Hmm.
Nothing has been discussed, Lordship.
Presence not.
Lordship, that in that case, my prayer is to list again the matter next week, Lordship, instead of passing.
So your appearance is on which date?
29
29.
29.
April, Lordship.
Yes.
29 April.
So we'll list it next day, next week.
Lordship, that can also
On
be
the
done.
next day, interim will be heard then.
Yes, Lordship.
Because in any case, prior to that, next date, you are not going to appear.
Yes, Lordship.
Okay.
In that case,
Okay,
after a
the
week
interim
time,
prayer
Lordship.
shall be taken. Okay, list this matter again on, not for a week, huh?
23rd, Lordship.
Okay.
Tuesday, Lordship.
That is
The
after a week, Lord.
Rest will remain, but then only the date, huh? Issue notice returnable by 23rd, huh?
Lordship.
Okay. Then the copy, etc. will be same. And then this is matter on 23rd, the interim, on which date the interim prayer shall be considered.
Bless you, Lordship.
Mother bless.
Just obtain instruction also, huh? Why their presence is necessary before the court, while there is a condition that, by which the IO can anytime call them. Okay.
Bless you, Lord.
Obliged.
For motion, item numbers 3 and 4.
Yes,
The police of Lordship.
yes.
My note, this IAS appeal, this IAS preferred in view of civil revision 12 for PT 23. Now, my note is IA 35. I have made this application under Order 1, Rule 10(2) for pleading additional respondents. So,
Why they are required?
my note here in my annexure, C, D, and E. C, D, and E. The deputy commissioner has summoned me before its court. Now this case is pertaining to a land dispute. Now in the civil revision, I have filed for the revision of the DB's court order, asking for de novo trial. So pending this particular case, the opposite party,
De novo trial before which court?
the DB court has decided this particular case.
Yes.
Now I have filed for a revision before this honorable court for a de novo trial, praying
But-
this honorable court to to grant me a de novo trial
Before which court? De novo trial before which court?
before a civil judge court, because
The
previously
case was decided by the
by the DB's court,
yes, DB's court.
the Dobashi's court. Now the Dobashi's court, in the first, in my civil revision, I have prayed that the DB court has not followed the procedure of law. So for that, I have prayed for the de novo trial. Now,
The decision, the was is decided against you.
exactly.
Okay.
So for that, I have filed for the civil revision.
Now pending the civil revision, the DC and the DC, the ADC and the EC, they have summoned me before the court.
During the pendency of the civil
Oh,
revision.
yes,
petition before this
exactly.
court.
Yes.
Somehow
So
for what?
it is stated in the state, page 12, Annexure C.
Yes,
So I read out page 12.
yes.
This is to inform to Kutsugono village that a meeting is hereby convened on 31st January 24 at so and so at the additional deputy commissioner's office chamber to discuss the issue pertaining Hekai land dispute. So it is pertaining.
Whereas
to
the case has already been decided.
It has already been decided.
Okay,
I have filed for a revision before this honorable court so that the case be tried de novo. Now the DC's court has summoning me before the court. So this case has nothing to do with the DC, but since the DB has passed the order, the DC is summoning me.
DC has issued this circular
Yes.
on what basis? On the basis?
On the basis to discuss regarding the land dispute.
No, the basing on what? Who filed complaint or?
Basing on the decision of the DB's court. Now, it has not been reflected in this particular circular. It has not been mentioned whether they are going to follow the DB's court order or whether they are summoning me for a compensation which has to be given. So I'm coming to that. But as of the present, since the DC has been summoning me before the court, I pray that the DC, the other three state respondents be implemented as party.
Okay, so
Yes.
and who else? DC and?
The
You
DC,
have
the
also
ADC,
paid for include
yes,
DC,
DC, ADC, and the
ADC
EAC.
for what? Why ADC?
It is before the court of ADC.
Okay,
Yeah,
and then why it is extra EAC?
yes, EAC. It is EAC because EAC has passed an order. EAC has passed an order that I should pay a sum of rupees 2 lakhs.
Where?
To compensate the opposite party. That will be in my civil revision.
Okay, civil
Yes.
revision. It was passed earlier only.
Yes, it was. I'm coming to that. Yeah, it was passed on 6 July 2023.
Before filing of this civil revision.
Exactly.
So why you did not include there at the time of filing?
No,
civil
at the
revision?
time of filing,
Hmm.
I have not been summoned before the EAC or the DC or the ADC's court.
Although the order was passed.
Yes. After that only.
But just the curiosity. So why this deputy commissioner had issued
Yes.
on the basis of at whose instance this order was passed? Circular.
That is exactly where I'm confused.
Okay, you do not
Yes,
know.
yes.
So that is so you want to implement.
Yes, so for that, I want to implement the ADC, the DC, and the EAC as party.
So now who is the respondent?
The respondent is the main respondent is the respondent number one.
One, okay.
Yes.
Will issue notice? Issue notice?
My lord.
But
And my lord, here in this, an authorization letter also has been submitted by the village council that since the petitioner, the first petitioner, he's not keeping well, he has authorized the head GB as petition number 2.
head GB?
Yes,
Why head to head GB?
because the chairman of the village council, he's not keeping well.
Okay, this
Yeah.
is filed by whom?
Previously, it was filed by the chairman Shitsui Chizo. Then subsequently, in this, it has been filed by Tekui Sapu. So, my lord,
So,
annexure A, page 10. Annexure A, page 10. This is the authorization from the village council.
so that means the revision petition was
Yes.
filed by different person.
Yes. So,
Can it be authorized?
yes, can be authorized. So now we have two petitioners. Petitioner number 1, who is the original petitioner, and subsequently petitioner number 2, who is also a member of the village. Because
This revision petition is not filed by the individual, it's by the members of
by the village council chairman,
village council challenging.
challenging the order of the DB's court.
Okay,
Yes. So my note in my this thing, annexure page 12. Annexure page 12,
how they are agreed by the DB's decision?
my note here, the DB's court has not.
The decision was between whom? The case was between whom?
The case was between the village council and one individual. Now the village council has passed a resolution that this forest property will be a common property. So that was passed way back in 2016. Now this case came up in 2022, where the opposite party, the respondent number 1, says that this is my property.
Private.
Yes. That was the thing. And for that, the respondent number 1 has filed this complaint before the DB's court. Then thereafter, the DB court has not followed the procedure of law. For that, the village council has filed before the DC. Now the DC, instead of taking up the matter,
DC or DB?
DC. The DC, instead of taking up the matter, has endorsed it back to the DB court. Now, first it was before the EAC, under the jurisdiction of the EAC, DB's court. Then I filed the complaint before the DC's court. The DC should have taken up the matter. Instead of taking up the matter, he has endorsed it back to the DB court at PEC.
Okay.
So this particular case has been decided before the DB court twice. Yes.
So now the DB decided the case
The DB has decided the case against me.
against
Yes, against the village council.
against the village council.
Yes,
Okay.
besides the village council having the village council resolution that this particular forest will be a common property. And that I have given my complaint before the DC also, but the
No,
DC has never taken up the issues.
But the village village council is the agreed party now,
Exactly.
not the villagers.
The villagers along with the village council.
How the villagers and the village councils have become party?
See,
The owner of the property is the villagers. But the
owner of the
village council
property,
is the council.
yes, owner of the
Who sit as a
property,
court.
see, the village council declared that this particular village, the forest is a common property. And that is a resolution in the GBM. So at that point of time, 2016,
Now,
at that
the
point of time,
Village council,
yes,
when it is, when to decide the dispute between the parties, sit as a court only.
yes,
Okay, then
And
how this village council is, my question,
my lord.
how this village council is aggrieved by the decision of the DB? Why not the villagers?
See, my lord, during 2016,
Hmm.
2016, the village council in a general meeting, they have decided that this particular forest will be a common property. There was no objection. Then after that,
That was decided in the capacity of village council.
yes,
Okay,
and each and everybody in the village council, plus the present respondent number 1 herein, has no objection at that point of time. But after that, the respondent number one here.
Whether, just a minute, this
Yes.
is IA and then the revision petition not yet admitted. This another 113 IA is for what?
113 is for the the condonation,
No condonation, not yet condoned.
not yet condoned. So for that, I'll come to that.
Now the
My
the
lord.
condonation petition, then it has to be
Yes,
in the
yes,
condonation petition only.
exactly.
In the revision
exactly,
and the revision petition not yet
Yes.
admitted.
Exactly.
Why it has to be in the revision petition?
My lord, it is like this.
Hmm.
I've prayed before this honorable court
Hmm.
to file a substitute notice
Hmm.
to the respondent number one. So the substitute notice has been affected to the respondent number one. That affidavit has been submitted before the court. Now, since the opposite party, the respondent number one, has never appeared before the court, I have prayed to this honorable court to for a paper publication.
Publication.
Yes, that also has been complied, and that was effected on 2nd April of 2023.
Yes.
An affidavit has been filed
Hmm.
on dated 10/4/24. So this is the affidavit.
Hmm.
It has been filed before the court.
Hmm.
So the opposite party, the respondent number one, is not coming before the court. Now what the respondent number one is doing, that I cannot say. But here the state government, the DC, the ADC and the EC have been summoning me before the court. Besides knowing the fact that there is a particular case pending before the High Court,
You have never appeared before the DC, ADC or EAC. Never appeared.
I have appeared before the ADC stating that I have a case before the High Court.
Hmm.
So pending this particular case before the High Court, I pray that I pray that the court of the ADC keep the matter in abeyance. This is what I pray before the court.
What
But
they
if-
what they wanted to decide.
That is exactly where I'm confused. Now, if at all it is the execution of the DB court, that is one thing. If it's the order passed by the EAC, order passed by the
You have
EAC,
not been served with the copy of the petition filed by the other side.
my lord, I can get it.
You do not know
Yes.
for what you have been summoned.
Yes.
And then you have not been served with any petition filed by any person.
Nothing.
So why you have been summoned, you do not know. Is it in connection with this present case then?
Yes, exactly.
How do you know?
Because here it is mentioned Hekhai.
Okay.
It is, the dispute is relating to Hekhai forest land.
So when you appear before the DC or ADC or EAC, you did not ask why you have been summoned.
My lord, Hekhai is the disputed area. And because of the disputed area of Hekhai, I am filing for a revision before this.
It was already decided by DB.
Yes,
So what they want to decide
that
now?
is where I'm confused.
Okay,
Yes,
you have not been told.
I have not been told. I've been, on the second of February, I've been told that the court of the ADC wants to resolve the issue of the forest land. Just that,
But then you see,
yes,
in the decision,
yes,
the impugn order
yes,
decided by the DB,
yes.
DC or EAC or ADC is not a party, not
No.
connected.
No,
Now is this not the separate case, separate one,
no,
the present one?
no.
How do we implement them in the case where they are not connected with?
My lord,
They are not connected, as you said.
they are not connected,
Hmm.
but they are the one who has been summoning me. In my in my annexure 12.
Why don't you challenge that order itself?
Of course, I can do.
That would be better because
Yeah.
here, if they are unconnected with,
Yes. But
what is
he-
the point?
But here, my lord, the subject matter.
They are not the party.
Yes,
They are not the party,
yes,
neither for you nor for them.
yes.
Then you challenge that order.
My lord, it's there also.
We'll issue notice to them instead of impleading in the case where they are not connected with. You challenge the said order separately.
Allow me to do that.
That will be better
Yes,
because
and in the meantime,
then the notice will directly go to them
yes,
why you have issued.
yes. And in the
And
meantime,
in the meantime, that will be stayed
yeah,
if they are calling not to call you. So that will be better instead of impleading in the case where they are not connected with.
of course, that is.
Hmm.
But,
That will be better. So here is, where do we
but
implead?
here,
Where
my
do we
lord,
implead them?
my lord, here,
Hmm.
I would like to bring to this court notice
Hmm.
that the following member are requested to attend the meeting without fail. Now, that is the PA to DC. Then the village council chairman.
When you are asked to appear,
That was on 31st,
31st of
January 2024.
January. No, that was
Yes.
earlier.
Then subsequently,
Subsequently, which
Then
the latest one is,
the latest one, I've been instructed that is on the 10th of April. But I'm yet to receive that particular summon letter. I'm yet to.
issued on 10th April,
Yes,
fixing next date on when?
on 10th. When was it issued exactly, that I don't know.
Hmm.
But I have been instructed that they have been asked to appear before the respondent on the 10th. That one I'm yet to receive it.
This was 31st.
Yeah.
Challenge this and the latest circular or the summon issued by the deputy commissioner will issue notice. In the meantime, will stay.
My lord, my lord.
Here it will be here because they are not connected with. Then now in the notice,
Yes.
they will have to show cause notice. They will have
Yes.
to reply why they have issued summon to you.
My lord.
Hmm.
But
Because here in this case, present case,
yes,
they are not a party.
they are not a
What
party.
answer they will give? What affidavit
Yes.
they will file?
But here,
If they are connected, then we'll impede them here also.
but here,
You can or
Your
make
Honor.
an application.
here, my lord,
Hmm.
see, since they have served this copy to me,
Hmm.
I have been compelled to.
Yeah,
But if-
that is why you do not know why they are calling. So challenge that order. You do not know, you said.
Yes,
You do not know whether it is connected with this present case
Yes.
or not. So
Yes.
challenge that order itself. Or make an application first. Give me the petition anyone filed by anyone against you. Serve a copy to you so that you can file reply or
My lord,
affidavit.
I have given a I've given a letter to the DC also, stating that, you see,
Any reply?
nothing.
Well, then,
There's no reply except for
then you-
except for the summon that's been given to
then
us.
annex all those, their circular, their summon, your application and challenge that order. That would be appropriate, I think, step.
My lord.
So this then, what do we do with this present one? In the meantime, present IA for impediment. You file tomorrow. You file, will issue notice, and tomorrow or today you can withdraw this. If that materialize, if that works, or keep it abeyance for the time being. IA.
Fine. Fine.
Okay. As prayed for by the Nana Council.
My lord, but in
You think about it. You think about it.
yes,
Because you are not revealing. If you think that it is in connection with this case and they want to decide this, that, then
Yeah.
you say they can be impleaded. You
Yes.
say that you do not know. Okay, as prayed for by the Nana Council for that. petitioner, list this matter after,
My lord,
yes.
I want to take you to IA 37.
Yes. What is this? This is also new.
Yes,
This is who? What for this is?
this application under section 151, invoking the inherent power of the court for staying the proceeding of the impugn order dated 11/4/2023 and the order passed by the AC court dated 6 July 2023.
No, but your condonation petition is still pending. Not yet condoned.
Of course,
Then
of course.
what happened in that condonation petition? Whether you have taken steps they have received? Have they received?
Yes,
No one appears.
no one appears. And the service through paper also has been this thing published, and affidavit also has been filed.
Okay.
Yes,
Has it been listed today also?
the one is not been
113.
listed. Then for 2024, it has been filed before the court.
113. Because even if the deputy commissioner, ADC or EAC is to be impleted, you have to implement them here in the condonation petition, because this is yet to be allowed or yet to be disposed of. Just a minute. So have you filed affidavit?
My lord, yes,
After paper publication?
yes, my lord,
Where do we find?
on the 10th of April.
Is it here? Where do we find your affidavit?
Yeah, my lord, on the 10th.
So only the last order, the respondent may be published into newspaper, and then thereafter, no records. Do you have the copy?
Yeah, I have my personal copy.
Not available.
I think we have received.
Huh?
We have received it.
It should be in the process. Yeah, it should be in the process.
Not yet.
Yes.
So then you see, if you have published.
Yeah.
So notice is complete. So for passing the order, we need that. So let it be listed. If he is not accepting
Yeah,
the notice,
yes,
and then despite of publishing in the newspaper, if he is not appearing, notice has to be treated as complete, and then order is to be passed in the IA for condonation,
yes.
condoning the delay. So you let it be listed with the affidavit.
Yeah, then my lord, let it be listed on Thursday.
Thursday.
Yeah, Thursday.
Okay.
And in the meantime,
Okay. Mr. Ejo, not counsel for the applicant in the IA condonation 113. Huh?
meantime, my lord, allow me to find out this thing. And appeal against the order of this thing.
You are at liberty to
PC.
file.
Yes.
You are at liberty to challenge those orders. The learning counsel for the applicant submits that although he has, after publication of the paper, he has filed an affidavit to that effect, but the same has not been, but the same is not on record. List this matter on Thursday along with the affidavit. Along with the said affidavit, okay.
And along with the IA.
And IA, so you so when you will file that? So these till then, this will be kept evidence
Yes.
prayed for by the learning counsel for the petitioner. List this matter after 2 weeks.
No, might not
Thursday.
on Thursday itself.
Okay. List this matter along with on Thursday. Okay.
Okay.
That is in 37, IA 37. Yes.
For motion, item numbers 5 and 6.
May I please, Lordship? Lordship, by this instance, civil revision petition, I'm challenging the impugned order dated 15/11/2023. The impugned order dated 15/11/2023 passed by the learned district judge, Mon.
So in the IA.
Lordship, this IA is for condonation of delay.
Or condonation of delay?
Yes, Lordship.
Okay. Mr. Will issue notice?
Okay, Lordship.
Mr.
Chingmai.
Learning counsel for the applicants. Para. This is an application under section 5 of the Limitation Act 1963, praying for condonation of delay of 42 days in filing the connected civil revision petition. Start. Para, issue notice, returnable by 4 weeks. The applicant shall take steps upon the respondent by a registered post with ID within 5 days from today. Lordship. Start. List this matter after 4 weeks. Okay.
Thanks, Lordship.
For admission, item number 11.
May I please, Your Lordship?
Yes.
Lordship, here, if the matter can be posted after on July, Your Lordship.
So
Your
what
Lordship, what has happened is-
happened to the amicable settlement? Has it been materialized?
No, Your Lordship,
Not yet.
they are still on the process, Your
Still
Lordship.
in the process.
Lordship, as per the information given by my client, Your Lordship, they are trying to settle the matter amicably within the family.
It will be better. They are blood brother.
Yes, Your Lordship, biological brother, Your Lordship.
May it please your lordship.
Yes.
I have a submission to make in that regard.
Okay.
The order was passed by this honorable court for the mediation, and the respective councils were appointed as mediators. And thereafter, we have initiated and tried to approach the opposite party for mediation, but it has failed. There was no forthcoming positive response from the opposite party. And the pleadings have been completed. And while this matter was fixed for admission hearing, this honorable court was considerate to allow and give an opportunity for mediation. However, since the filing of this particular petition by the petitioner, there has been multiple prayers for adjournments. And even after the court's direction to try and settle the issue through mediation, there is no positive response from the opposite party, and they have been seeking adjournments. And even today, the leading counsel is not present. So this is an indication that they are not interested to pursue this matter. So my humble submission is that if they are not interested, that the matter may be dismissed, Your Lordship, because a criminal complaint is already been filed before the lower court. And this is a matter which facts and records has to be examined by the trial court, Your Lordship.
Just a minute, who filed? You have filed.
No, Your
Yeah.
Lordship,
What you filed? Challenge.
criminal complaint we have filed before the lower court and
Criminal complaint filed by you.
Lordship, yes, Your Lordship.
And you have filed this for court.
Yes, Your Lordship.
Criminal complaint.
Lordship, the criminal complaint is kept in
What-
evidence, Your
what-
Lordship.
What
Okay.
is the status of that
Your
complaint?
Lordship, if Your Lordship would come
Investigation?
to the order dated 19/7/2022, Your Lordship.
19?
7/2022, Your Lordship. The first order, Your Lordship.
Yes.
Your Lordship would come to the last para, number 7, Your Lordship.
Para 7.
7, Your Lordship.
Hmm.
Lordship, here if I may be allowed to read it, Your Lordship.
Yes, please.
Having regard to the projections made in a criminal petition and the nature of the allegations made in the criminal complaint, CR case number 02 of 2022, Your Lordship, which is a prima facie appears to be a civil in nature, Your Lordship. It is observed that till reasonable that the further proceedings of the criminal case here, so and so presented pending before the learned CJM, Your Lordship, Kohima shall remain pending, Your Lordship. Lordship, here also it was observed that it was a criminal matter, Your Lordship, civil case, Your Lordship. And Your Lordship here declines, Your Lordship, the parties, they are ready to decide, Your Lordship, they are ready, Your Lordship. Your Lordship, if the matter can be listed on the first week of July, Your Lordship, till then the parties may be allowed to settle the matter. Lordship, we submit that this particular order was passed in the absence of the respondent, Your Lordship, and we have not been given the opportunity to repart the submission given by the petitioner.
Have you filed any vacation petition?
No, Your Lordship, nothing.
No,
is
Your
paper.
Lordship.
No, Your Lordship.
Then?
We were on the impression that this matter will be heard as soon as possible and settled, because this matter has been filed during the year 2022. And it's still,
You have seen that the court has also made some observation that. Just a minute. Let us go just 1 minute, one second. Where is the FIR? Just would like to see once. Okay, so this is criminal complaint before the court only, I think.
before the court, Your Lordship.
Yes, yes. Earlier FIR was filed,
Lordship. Yes,
then it was not registered.
Yes, Your Lordship.
Then only this complaint.
Only this criminal
And then court has also observed that probably.
civil in nature. Your Lordship,
Civil in
cognizance
nature.
has been taken by the lower court, Your Lordship.
Hmm?
Cognizance has been taken by the lower court.
Maybe.
Yes, Your Lordship.
Hmm.
So there are evidences and there are records which has already been filed before the lower court. This is a matter of evidence, Your Lordship. The parties have to be examined and the the documents have to be examined, Your Lordship. And even the mediation has.
The record has been called for.
The earlier occasions.
Is it original record or scanned? Record? Have we received the record? No, not yet. Not received.
No, wasn't being confirmed.
Okay. And then probably subsequently,
Lordship.
there is an order for amicable settlement.
Yes, Your Lordship.
And then probably that is why record also not been called for. And in absence of record, it will be difficult also for us to dispose of on
Yes,
merit.
Lordship.
And if you're insisting, we need to call for record.
Lordship. Lordship, if the matter can come up on July, Your Lordship, in the meantime. In that case, my humble submission is that since the mediation has failed, the matter may be fixed for hearing, Your Lordship. Because the pleadings have been completed. Lordship, July, Your Lordship. And the process of the court cannot be frustrated in this manner, Your Lordship. After filing the petition, the leading counsel cannot seek adjournment multiple times in this manner, Your Lordship.
You have for respondent number?
For the petitioner, Your Lordship.
Or you have for petitioner?
Lordship.
You have for respondent number 2?
Lordship.
Have you also, no objection? There is court observation also, huh? You just obtain instruction, one more, or last chance can be given because they are blood brother.
Lordship, this morning only I have spoken to the respondent. And apparently there is no discussion between the families. They are not in talking terms.
Some role on the part of the advocates are also there.
Yes,
Under
because
the
with that regard,
technical
your lordship,
circumstances,
yes,
because
that
they are
we have-
blood brother.
yes,
And we
I
need
agree,
to
your
tell
lordship.
it's a duty on the part of the land council to tell them that the court holds also made some observation that probably this is of course civil nature. Decision will be of course on merit only, but then court in the prima facie court also made some observations. So this thing need to be told to the client that under the circumstances, it would be better to settle the matter amicably between the brother.
Yes, your lord.
So instead of
Lordship, in that respect, we have approached the counsel of the opposite party on 2 occasions, but they have not been responding positively, your lordship, which indicates that they are not interested in the mediation also. Your lordship. On 29 September 2023, as well as on 10 October 2023, the counsel, my learned friend who was appearing during the time when this particular order.
and then you see after after filing, then only
Yes,
only to pray for adjournment. Why should we also use?
No, your lordship, the leading counsel, your lordship, BP Upadhyay, your lordship. As per his instruction, your lordship, they
Who is the
are
leading counsel?
BP Upadhyay, your lordship.
11.
Your lordship, instruction has been given that.
Okay, Mr. I'm sorry.
I'm sorry, your lordship.
Land counsel for the appearing. Your name is also there?
Yes, your lordship. My
Okay,
name is.
Land counsel submits that the leading counsel, Mr. B.K. Upadhyay is.
Your lordship, you have given instruction that you have talked with the client, and it seems the family, they are trying to settle the matter amicably between the families, your lordship. That's the instruction.
Okay. Submits that he has an instruction that his leading counsel, his senior leading counsel, Mr. B.K. Upadhyay. He has an instruction from his leading counsel, from his senior leading counsel, Mr. B.K. Upadhyay, that the families are trying to settle the matter amicably out of court and prays for some more time. Stop. Mr.
Zakato Chishi, your lordship, on the contrary.
Last chance we'll give them, last chance.
Lordship.
Submits that in the earlier occasion, the parties failed to settle the matter amicably outside the court, and then prays for decision of the case on merit.
Lordship.
In the fact and circumstances of the court case, a last chance is given to the party to settle the matter out of court.
Lordship. If the matter can be fixed on
Please
1st of July.
list this matter. First of
July, your
Lordship, a
lordship.
short date may be given because in the previous occasion also they have sought 2 months' time. After the passing of order.
1 month is
1 month, your lordship.
list this matter after 4 weeks.
Your lordship, if it date be fixed, your lordship.
Date.
Date, your
When
lordship.
do you want?
Lordship.
Is prayed for by the Land Council for the party. List this matter on
Lordship.
turn this
27 of May, your lordship.
27 May. Okay.
Lordship, that's quite a long duration.
Lordship,
It's
just 1
fine,
month, your
it's
lordship.
fine only.
Lordship, meantime, the parties, they can decide, your lordship. In the meantime, the parties, they can decide, your lordship.
That is always
Settle
there.
between
Already
them.
there is order.
Lordship.
Last chance given, I've said.
Lordship.
Okay. Because one side says that totally not agreed,
Yes,
and then you have given ample opportunity to settle. Not yet, right?
March,
Please.
Lordship.
For admission, item number 14.
Yes, Lordship. Your Lordship, if the matter may be listed after 2 weeks, since the conducting counsel is indisposed.
Okay. Ms. So submits that the leading counsel is indisposed and prays for listing this matter after 2 weeks. No?
Lordship, I'm for respondent 2.
Okay, Mr. Mr.
Lakshmi, Lordship.
Land Counsel for the respondent number 2. And you are also?
No, state.
Okay. Mr. Angami for the state and Mr. So for respondent number 2 are also present. Huh? Angami first, then.
There is an interim, Your Lordship.
Hmm?
Interim, there is an interim.
Interim also there. Okay. as prayed for, as prayed, comma, list is matter after 2 weeks, stop. The interim order pass earlier shall continue till the next date. Okay.
Much obliged.
For admission, item number 21.
Please, Your Lordship. My lord, I filed my recast, but since there is an error,
Yes,
since there is an error, allow me to withdraw this recast and then file a fresh. Only pertaining to para 4. I
which
file
one? Which one?
recast application.
IA,
Yes, IA.
in the IA,
Yes.
you want to withdraw?
Yeah, I want to withdraw and file it fresh because there is something which had to be added was inadvertently missed out.
You are for respondent.
Our Lordship.
Any
But at any cost, this will not survive.
Let them try.
Yeah.
But you know that it will not survive.
Let's see.
Let's see.
Not at all,
You want-
because see,
Hmm.
Your Honor, Lordship, may I take your Lordship to the order which that is challenged by the petitioner here. Order dated 21/7/2022, passed by the DB's court in the civil revision, that revision. Lordship, to the IA, which is fixed today.
So he wants to withdraw. Hmm?
Withdraw and file a fresh on the recast. Only pertaining to para 4.
No, whether paragraph, if you withdraw means it's withdraw only. If you want to withdraw, it will be withdrawn only.
You withdraw and file it fresh.
Okay. Hmm.
Yes.
Lanet? Okay. Mr. And if so, Lanet counsel for the applicant wants to withdraw this application with the liberty to file a fresh. If so,
Within 1 week.
hmm?
Within 1 week.
Okay, if so advise, stop. This. Just a minute. They just submits that, there is some error.
Yes.
There is some error in the application. And he, which required to be, which required correction and which required correction and to file a press. By filing a press, stop. And press for allow him to withdraw with liberty to file a press. Stop. Mr. Land counsel for the opposite party is present. Stop. Is prayed for by the land counsel for applicant. This application is dismissed on being withdrawn with liberty is prayed for. Okay. And then this was also registered. Then then the revision petition also.
That will go.
And what is this IA? Another IA? Okay, that was for amendment. That was disposed of.
I'm free to file a recast.
This was also disposed. Not mentioned. Okay, so this was disposed. In view of the order pass in the IA, C 111, this civil revision also is dismissed on being withdrawn.
My lord, civil revision,
It will remain.
it will remain
Haha.
because
Hmm.
until if this thing, if the IA is being disposed, then the civil revision goes. But so far as the IA stands, the civil revision subsists.
IA you have withdrawn.
Yes. Yes, I have withdrawn to file it afresh.
Yes,
Yeah,
withdrawn.
only
We can
the
file it
IA.
together, these two can be filed together.
Hmm?
These two can be filed
Yes,
together.
this two can over and again.
My
you have to
lord,
fight together.
I'm only talking about the IA 111.
Yes,
Yes, only that.
this is
Now, if the
on
IA is
you
gone,
unless-
then obviously the civil revision goes.
okay.
Yes.
Until unless condonation application is allowed,
Hmm.
there is no
This
question
should-
of filing civil revision.
This should have not yet been registered even,
Yes.
but then it has already been registered. It goes.
Yes. So if at all.
In order
required, let
to
them come
file
with the
this only
application.
with the request to file this,
Yes.
you have filed this
Yes.
IA. So since the IA has gone, it has not yet been come into existence. It automatically
My
goes.
lord, my
We
prayer
can
is
file
there.
together.
My prayer is there.
Hmm.
Allow me to withdraw the recast and file it afresh. Because I am saying that there is an error in para 4. Only that.
So you mean to say
So
that
I cannot file a recast alone.
In that case, you have to file
The
another
civil
application.
civil revision should subsist.
hmm?
Civil revision will subsist. Because IA has already been admitted and recast has been prayed to amend the IA, that's all.
So civil revision will remain.
Yes.
It has not yet moved, huh?
Yes,
Will it remain?
it will remain. The civil revision will subsist because IA only recast has been prayed to be withdrawn and file afresh, recast. So the IA 11 still subsists. Plus the civil revision. I'm not withdrawing my things. IA 111.
Civil revision. Huh?
Yes, I'm not withdrawing this IA 111.
Which one you are withdrawing then?
I'm withdrawing the recast only.
Which one?
I have prayed the court, I have prayed to the court.
Which
to
one
file
is
a
recast?
Recast to the IA 111. IA 111.
Recast?
Yes.
You have filed another?
Yes.
There I haven't seen.
IA 111 subsists still.
Okay, IA remains.
Yes.
So recast is for what?
Recast is on the IA 111 in relation to para 4. It has been placed specifically before the court. On 18/3/24.
Just a minute, there is one.
Yes.
It has not been separately numbered.
Nothing. IA 111 arising out of the civil revision only.
Recast is only in context with the IA 111.
Why it is, so it has been not given a separate number. It is
My
in the-
lord, recast
Just a
will
minute.
go.
Just a minute. This was filed. Yes, there is one, 26 May. And then IA was filed earlier. So you want to withdraw this recast?
Yes, I want to withdraw this recast and file afresh the recast.
Okay, then.
Yes,
we need-
only that.
We need to change it.
The number of.
There is one petition. Have you served this copy?
This has already been served. This recast has already been served.
I have IA number 111 of 2003. But no other
23.
IA
223.
223. What is this?
Recast also has been furnished to the opposite party.
Whether this recast was allowed earlier?
Yes,
By
it's
which order?
allowed on date of
By which order?
18/3/24.
By which order, huh?
18/3/24.
18?
3/24.
18/3/24. Okay, then it's changed, huh? Mr. Izel, Lawyer Counsel for the applicant. Submits that the earlier same thing, huh? There is some error in the recast. Now it will say, it will be a recast.
Yes.
Recast paragraph number 4.
Yes.
Of the IA number 111, 2023. And pray for allowing him to withdraw the same. Stop. Huh? The prayer is allowed.
To be filed afresh, my lord.
And then allowing him to withdraw the same with liberty to file afresh. Stop. The prayer is allowed. The prayer is allowed, huh? Okay. With liberty is prayed for. Stop. How much time you say?
1 week.
Okay. So list this matter after a week. Okay. Okay. His presence may also be recorded, huh? And this is in line. Okay.
Obliged.
Yes.
For hearing item numbers 27 to 30.
27 is COP. This is WPC. Where is the 27? This is 27. 27 is WPC. Where is this? 27 is WPC. Okay, COP. Oh. Okay, this 27 was not has not been listed for long. 27, no? Item 27, isn't it?
Yes, on 30th of November, it was.
It was last listed on 23 November
Yes.
2023.
It was on 30th November 2023, it was heard, your lordship, part heard.
Which one? This one?
Yes,
Item
that-
27?
No.
No, I'm talking about item 27.
Yes.
It was last listed on 23/11/2023.
Yes, all
Is
these.
it connected with the
Yes, all these are,
sim
all these are connected.
connected?
Yes, connected cases.
Okay. So which one you want then to be taken up?
Since that the most recent one, that is WPC 88 of 2022.
88 is 30, item 30.
30, yes.
30 goes, I think. It is. Item 30 is
88,
oh yes, 88. No, this is contempt. Yes. Just a minute. And just a minute. This was last listed
on 30th of November.
Is it?
Yes, your lordship. It was heard in part.
Just a minute.
Yes.
WPC 88. It was listed on 30th.
Yes. 30.
Any order passed on that day?
No, your lordship, it was heard in part and this.
It was heard in part.
Yes.
Not in the order.
Some dictations were also done on the day. Whether it is on record or not.
Not in on record. So not in the order sheet.
Oh.
There is who was also content 23. No, it is with 28. Okay. So this should be, so this should have been in the, it is in the content. The
Yes.
order is in the content. List the matter. Okay. This should have been in the main case, huh? Not in the content.
Yes.
Yes. So you want this 88 to be taken up first?
Yes.
88.
Yes.
Okay. So what is this matter about?
This is with regard to.
So just let us ensure the parties 30. So who is for the respondent?
Lordship, for the state respondent.
State respondent?
Yes.
in all the three writ petition as well as the, for the,
Contempt.
respondent number one in the contempt.
Okay. All the respondent.
Oh, no, your lordship. There is a private respondent in the WPC 58 of 2017.
This is 88, huh? WPC 88, state. Additional deputy commissioner, home commissioner, deputy commissioner. No, so I think that in 88, you represent all the respondent.
Correct.
1, 2, 3, 4.
Correct.
So only in the contempt there will be private.
Lordship, in
No,
WPC 58 of 2017 and condemned, I am appearing as respondent number 6 in WPC 58 and condemned 23 of 2022, respondent number 2, Lordship.
Okay. So, but in the 58, there is a private respondent also.
Lordship, right? Respondent number 6, Lordship.
But
Yes.
in 88, there is no private
There
respondent.
is no private respondent,
You said that it's all the same,
but they are all connected,
Connected.
connected to the same land.
same lane.
Yes.
And then, yes, here respondent number 4 is Ohed Devasif.
No, there is one union,
Monyo
Monian Union.
Lordship.
There should be.
Okay, Monian Union.
Yes.
So here in 88, this union is,
No, it is not.
okay, only state.
Yes. The petition, the land, which was,
And then the contempt is also against this union.
yes,
Lordship,
against the
Lordship.
union and the,
Respondent number 2 and the state is respondent number 1, Lordship.
Okay,
In the last occasion on 13/2/2024, we had the part hearing where the submission of the petitioner was done, Lordship.
yes. So that submission probably has not been recorded. Not on record. No. Who took on that day? Just a minute. In the contempt. It was Chelsea. Chelsea probably has recorded some. Chelsea. Okay, anyway, we'll have hearing. Yes,
Your Lordship, before going through the records, the brief facts of the case is that in 1971, it was during the early days of the, after Nagaland got its statehood. So in the area, that is the Mon district area, the petitioner's father was one of the leaders of the NGOs who helped the fledgling state officers in the area for establishing this district town. So in 1971, after land, because land in the entire area belongs to the villages. So the petitioner's father and the leaders at that point of time, they managed to get concessions from the various villages for establishing the district town. So in recognition of his service, the then district administration issued a special permit for farmland in that area. Special permit for of farmland. What happened was the petitioner at that point of time was a minor. 1974, the petitioner's father expired. Then
it was given to your father.
yes, yes. So encroachment started when the petitioner was a minor. Then the petitioner approached the administration. The administration also again issued 1978. The administration also held that it is his land, that no encroachments, that those who are trying to encroach, they are prohibited. However, encroachments went on, and then the district administration also started granting permits to department with the various departments and also to individuals. The administration also on the land which the petitioner was granted.
Your father was granted
Yes.
allotment.
Yes.
You have a
As-
document.
Yes, it is there.
Say around for how long?
The measurement In the initial allotment, the exact measurement is not given, your lordship, but it is a farmland. Boundaries were erected, boundaries, at least a rough boundaries were erected by the administration, and then it was given to the petitioner's father. Now, when this encroachment started, the petitioners was running from pillar to post until finally he approached the chief secretary. The chief secretary, and in the year 90. It was in 96. The chief secretary also directed the deputy commissioner to make an inquiry and submit a report. In the report, in the chief secretary's letter, it is clearly laid down that the administration should always honor commitments given by previous administrations. Now encroachments, a complaint has reached that encroachments are there. The district administration is directed to immediately conduct an inquiry and submit a report for appropriate action. What happened? The district administration sat over the matter. So the petitioner was finally compelled to approach this honorable court by way of a writ petition. The writ petition was WPC 204K of 2012, in 2012. Now this writ petition was disposed of by this honorable court with a direction to comply with the chief secretary's direction to the deputy commissioner. That is a letter of 99. And to pass necessary final orders thereon. Now, based on that, inquiry was conducted by the administration, and they have arrived at a conclusion that the administration has also granted allotments to departments as well as individuals. The petitioner has also made allotments to private individuals. And all this, that was submitted.
Who made inquiry?
The deputy commissioner, that is, since it is under the ATC district, the additional deputy commissioner conducted the inquiry.
Submitted
the inquiry report, yes. Now, to the deputy commissioner for onward submission to the government. That is the secretary, chief secretary.
What was the report in the inquiry?
In the inquiry report, I'll take your lordships to the inquiry record later on, but just the crux of the case. Yes, just the crux of the case.
Yes.
It was submitted. Then in the meantime.
Now, what was the report?
The report was finding that land was actually allotted.
To the petitioner?
Yes, to the petitioner, it is legitimate. The measure of the land is also given. And the finding is that with administration has also made allotments. The petitioner himself has also made some allotments. Those are the findings. Now what happened while this process was going on, the ADC's court, that is the Tobashi's court, passed orders, evicting orders directing some of the individuals to whom the petitioner has allotted some plots to vacate the land. Aggrieved by that, the petitioner has approached this honorable court by way of the WPC. Here are three WPCs, the WPC 207K of 2016, your lordship. The WPC 207K of 2016.
No, the Bashis passed order for what?
The Bashis passed an order directing some of the persons to whom the petitioner has granted some plots on the land to vacate.
Vacate for you?
Those individuals.
Those individuals,
yes.
The Bashis decided.
Yes, the Bashis.
Those individuals should vacate
the land.
Give the possession to whom?
No mention that about that, but to vacate the land. That was the order which was issued. I'll take your lordship to the order, your lordship. I'll take your lordship through the record.
Okay,
But
later on.
but the fact is that
Yes.
this order was issued. Aggrieved, the petitioner approached this court by way of the first petition to quash and set aside the Tobash's order of eviction of the.
Whether the versus order for vacation was included your name?
Because it is my land, allotment was given by me, but then this order was issued to them. But I am the owner. So I had to approach this honorable court by way of the writ petition, and it was stayed. That is the first case. That is I'll take your lordship through the various record. It was stayed in the WPC 207K. In that, the Tobash's order of eviction was stayed. Then again, in 2017, still that inquiry and the final, no order has been passed on the basis of the inquiry that was conducted earlier. While this was going on, again, in 2017, the private respondent, that is the union, encroached upon the land and problem arose. What happened was that Tobash's court, again, in this case.
Union mean the respondent number 6?
Yes, the Monian Union respondent number 5. Respondent 6, yes, Your Lordship. What happened was they approached the TB's court because the land which they were trying to grab was one plot where the petitioner has already allowed one machinery to construct a building. Now they wanted that particular plot, so they approached the Tobash's court. The Tobash's court directed for eviction of that person.
Number 6 approached the Tobash's court.
Yes, Tobash's court. The ADC, it falls under the ADC. Is it? So the Tobash's again issued eviction in respect of that person also. So the petitioner was compelled to approach his honorable court by preferring the WPC 58K. And the impugned orders were also stayed in this case. Now, pending these two cases, again, the state respondents decided to take away the entire land, allowing the petitioner a small plot of land where he is already staying. And that, in exchange for that, the petitioner's father,
during the pendency, government took all the land.
And then while these two cases are pending, the Home Commissioner issued the impugned letter saying that we'll take away the entire land. The permit which was granted way back in 1971 is cancelled. The petitioner will be allowed to reside only in that area where he is presently residing. That is a measure is also given. And then, since the petitioner's father has rendered yeoman service to the administration way back in the late 60s and 70s, in recognition of that, a school will be named after him. That was the order which was passed by the Home Commissioner, the letter which was issued to the Deputy Commissioner. Aggrieved by that, the petitioner has approached his honorable court. So that is the crux of the case. Now, Your Lordship, I'll take Your Lordships through the
Okay, this is the last order where the commissioner has issued an order whereby the allotment of the land to the petitioner was cancelled,
Yes,
and then he has been given only a small plot of land.
Yes.
This is the last order.
that is the
Which is under
last, that
challenge.
was a letter, yes, that is the one which is under challenge.
Before this writ petition.
Before this, in this writ petition, in the, but I have made, I have laid out the entire story referring to the earlier two cases also, where the orders have been challenged. And I have also annexed the the orders passed, interim orders passed by this honorable court in those two cases. So if the present, the last petition, that is 88, is heard in its entirety, then the other two will be covered by this also.
So other two, how the other two are connected?
The land is the same land.
Same land.
Yes. And then
other two is filed by somebody.
No, the petitioner.
Petitioner.
The same petitioner. The same petitioner.
Challenging what?
Challenging orders issued by the district administration, that is the Bashir's court, for eviction of persons from the land to whom the petitioner has made allotments. And in one case, in all the three cases, in all the two cases, it is the same. So the petitioner has approached his court. It has no authority to pass any order when the land is mine to evict persons to whom I have already granted the land. So, agreed by that, I have approached his court. In the meantime, again,
why you say land allotted by you means? You have also given some land.
I have, since it is my land, I have made some.
So they are
allotments
still
to some
possessing.
individuals. Yes, I am still possessing the entire land. Only thing is that the government has been encroaching and then issuing permits to others to enter into the land. And
then what happened to the person to whom you have given land?
they are still there, but since the order is a little, it is a.
The commissioner, home commissioner, cancel the land of those person also to whom you have already given.
The commissioner has cancelled the entire permit.
Okay,
The entire permit here.
Okay,
But in the earlier two cases,
including
yes,
the land to which the government, the district administration has also allocated.
yes, all that
entire land.
Yes, has gone all the way.
Saying
back
what?
to
Saying what?
1971.
Saying what?
The only saying is that the government needs land.
Okay.
So we are cancelling this permit. Petitioner shall have only that plot where he is staying. And in recognition of the petitioner's further service in the early, during the early days of the statehood, we shall name a certain institution in the petitioner's father's name.
Okay, in the entire plot, the government is trying to establish some institution.
No such institution. The only thing is they are just cancelling it. We need land for expansion of the town area. That is the only reason given by the state respondents.
Okay.
And it is arbitrary. They cannot.
So what is your ground?
If they have to take away that, they have to follow the due process of law. Now, if they want
no notice was issued.
Your Lordship, inquiry was there. There were meetings every now and then. Some suggestions was given that these things should be done in this manner by the district administration also. I'll take Your Lordship through that. Since the details are in the record itself.
Okay.
I will take Your Lordship through the record.
Okay.
But the first thing is land has been granted to petitioner. Now, if it is to be taken away, it has to follow certain procedures. If the state wants to acquire it, they can apply the Land Acquisition Act, Requisition Act. Compensation has to be paid. But without doing that, just arbitrarily taking the whole thing over. It is unconstitutional. So that is my only case, Your Lordship. So I'll take Your Lordship through the records from the Genesis until the end, Your Lordship, so that Your Lordship will get a clearer picture of the entirety of the facts. Lordship, starting from page 28, this is an agreement. Page 28, the typed copy is in the next page, page 29. This agreement is stated,
Just a minute, this is, oh, amended, in the amended petition,
yes,
you have amended the petition also.
yes,
This is amended means recast petition,
yes, it does.
28.
Yeah, we did not recast. No, no, no amendment was done in this case, Your Worship.
88 WPC,
WPC 88.
amended petition in WPC 88.
We do it. Hold on a minute.
It appears that the original
Rectified.
WPC 88 has been
Yes,
amended.
Yes, Your Worship. This is the one, right? Yeah. Yes, Your Worship. Yes, page 29 it starts. Page 29, Your Worship. It is the original order, a copy of the original order, which is signature A. It is not, Your Worship.
You have a typed copy.
Yes, typed copy is at page 30, Your Worship. Typed copy. This is an agreement.
Here.
This is 13 November 1968. We, the undersigned ANGs, GPs, and members of Digit Circle desire and agree to change the name of the circle from today and thereafter do hereby willingly consent to locate the circle HQ in a suitable place in Digit area. We further objection from any source on this regard should be entertained. Necessary land required for the HQ will be given without objection. So the various villages, they agreed to the government's proposal for setting up renaming the Digit Circle to to locate it at as the circle headquarters, and that the villages, all the villages will grant the government sufficient land. Since there is no government land in Nagaland, so whatever land is required by the district administration for setting up this headquarters will be granted. In this, Your Lordship will see the petitioner's father at serial number 1. Yes, yes. Serial number 1. It should be L Wang Shu. There's a typing error, Your Lordship. It is Wang Shu. Petitioner's father. Now,
I don't understand. Oh, what is this? Understand? ANGS. What is this?
Angs, they are like kings among the Konyak tribes. They have their traditional leader, traditional ruler called the Ang. The Ang is like a king. It's a unique institution among the Nagas. It is they are to be found among the Konyaks.
So this is called Digit area.
Yes.
Okay. So for establishment of headquarters.
Yes. So land was sufficient land, more than sufficient land was granted by the various villages.
Yes.
Now, the petitioner's father was instrumental in bringing about all these arrangements, Your Lordship, on behalf of the government, helping the state. Now, page 31 is the allotment, special permit. Page 31. Page 31 and the typed copy is at page 32, Lordship.
This is
special permit for farmland at Digit. This allotment was given to the petitioner's father in 1971, 29 March 1971. If I may read, Your Lordship.
yes, please.
Shri L. Wangshu Konyak, RCM is allowed to continue cultivation of the low-lying areas, which he has already put under paddy cultivation at Digit. The line of demarcation will follow as follows. 1. A straight will be drawn from a point on Sonari Mon Road as shown in the survey map till it joined another survey mark near the private track as shown in the survey map. From the survey mark point, it will run straight south till it reaches the first line of banana trees, under which it will turn straight northwest till it comes parallel to the point marked on the stem by me on 24/5/71. Taking the last point of northwest line, a straight line should be drawn towards south, crossing the marked stem line. Stem till it reaches another mark on the dead trees. From this dead tree, a line will continue straight for a few yards, then turn southeast and join the now Chum area. Following the area already Chum this year, a line should join Digit River near the pool called Chizak. Besides this area, he is also allowed to continue paddy cultivation at the confluence of Digit and Dash, being shown in the map as besides these two areas, he should vacate all the areas he has put under cultivation immediately. The EAC Mon, who was with me, is requested to go down and put boundary pillars with the help of Sri Wangju and his laborers. So, sketch map is given. We cannot make head or tail of the descriptions given above, but the map, it's a kind of a box somewhere in the middle showing 1975. So this demarcated area should be in the map, the next page, Your Lordship. There is like a box there. So this should be the area. The lane area is not given, but clear boundaries were constructed, Your Lordship. Now, unfortunately, the petitioner's father expired in 1974. In 1974, leaving the petitioner a minor. School-going minor at that point of time. So now, what happened was...
Fathers expire on?
In 1974, I have given the exact date has not been given, but I have made specific statement that he is expired in 1974.
Yes. In
paragraph.
No death certificate.
No death certificate, but it is not a disputed. It is not disputed at all, Your Lordship. Paragraph 4. Paragraph 4, Your Lordship.
Yes.
The petitioner is the eldest son. So all his siblings, they were minors at that point of time. Now, taking advantage of the minority of the petitioner and his brothers, the villagers who had contributed the land decided to encroach and take over the land. So what happened? The guardian of the petitioner filed a complaint before the district administration. That was and the order, which was the memorandum, which was passed by the district administration, is at page 34. The order. This was on 11th April 1975. The typed copy is at page 35, Your Lordship. If I may read, Your Lordship.
Yes.
Memorandum. This is Office of the Circle Officer, Digit, Mon District, Nagaland. Whereas complaint has been received from GBs and ANGs as well as public of Yong New Village that Sri Nokman Konyak, Chief Ang of Chapoka Village, and Sri Dingbong Konyak TV attached to the circle officer's office, Tizit, have encroached the land allotted to late Wangshu Konyak at Tizit headquarters, and now holding by his eldest son, Sri Nokman Konyak, White the then Additional Deputy Commissioner Mon, Special Permit Memo number so and so, dated 29 March 1971, under the signature of Sri T.C.K. Lotha, IAS, the then ADC Mon. I have personally verified the boundaries and shown in the said permit with the help of Sri Biwang Konyak, TB, and Sri Achok Konyak, TB, in presence of the said holder and the GBs and Ang and publics of Yanu village on 11th April 1975, and found bamboo grooves, banana tree stumps, trump of a dead tree, papaya trees growing prominently in the said boundary. Therefore, I do not find any reason as to how Sri Nokzam Konyak and Sri Dingbong Konyak can claim the land by encroachment. I therefore uphold a special permit issued by the erstwhile Additional Deputy Commissioner Mon, and further allowed Sri Nokman Konyak, son of late Wangshu Konyak, to cultivate the whole plot of land as allotted to his father under the present care of Sri Zani Konyak, who is closely related to late Wangshu Konyak and resides at Tizit headquarters. Since Sri Nokman Konyak is reading in school at Mon, but in no case Sri Zani K can claim ownership of the land. Also, Sri Nokzam Konyak and Sri Dingbong K should stop encroaching the said plot of land immediately in order to avoid further complications. So those encroachers were directed not to encroach. That it is a land granted way back in 1971 to the petitioner's father. No one can take it. That is the crux of the memorandum, Your Lordship. Yes. Now, there is this letter which is at page 36, Your Lordship. This is issued by the Office of the Sub-Divisional Officer, Civil Tizit Mon. I have made statements concerning this. And this is Annexure D. So, Your Lordship's paragraph 6, I would like to, in order to give the exact detail, I'll take Your Lordship to paragraph 6 with regard to this page 37, Annexure T. Paragraph 6, page 10, Your Lordship. I would like to refer to my statements only because it gives a clearer picture than me trying to explain it, Your Lordship. That is one. Paragraph 6, that subsequently again in 1981, some individuals from Chapoka village, having raised an issue before the administration that the Chapoka village had offered 1,200 acres of land on compensation basis to the administration for establishment of Tizit headquarters, and that the petitioner's farmland also falls within the land offered by the village. The then sub-divisional officer Civil Mon intimated the petitioner to submit supporting documents, and the petitioner having produced the required documents, the said officer, white letter number so and so, dated 18/7/1981, that is the Annexure D, inter alia requested the Deputy Commissioner Mon to clarify the petitioner's case, since the permit in favor of the petitioner's father was issued from the Mon office. However, no clarification whatsoever was issued by the office of the DC Mon in pursuance of the SDO civil letter dated 18/7/1981. That is with regard to the Annexure T, Your Lordship. Now, paragraph 7. That meanwhile, with the expansion of the town, the administration also began issuing allotments in the petitioner's land for establishment of department offices and also to individuals without the knowledge and consent of the petitioner. Overwhelmed by the rampant encroachers, the petitioner submitted a complaint before the Deputy Commissioner Mon. But the Deputy Commissioner, instead of taking appropriate action, white number so-and-so dated 9/3 1994, forwarded the matter to the Additional Deputy Commissioner DZ to examine the petitioner's farm and issue eviction orders. The Additional Deputy Commissioner, however, failed to act upon the letter of the Deputy Commissioner Mon. Therefore, the petitioner published a notification dated 13/12/1995 in the Nagaland Post cautioning encroachers, so that the records are to be had found at Annexure E1 and E2, which is at page 38. Page 38 is the letter issued by the yes. Here it is clearly written down. Therefore, you are requested to examine the farm and issue eviction order as an early date. Now, the Mon office, that is the Additional Deputy Commissioner, sat over the matter. No order was issued, despite this recommendation by the then subdivisional officer. Now, petitioner was compelled to publish a notification declaring that the land is his and that no encroachers would be allowed in short. That is a notification which is at page 39, notification.
Is a paper publication?
Yes, it is a newspaper publication. It is published in the Nagaland Post. December 13th.
But it is the 38 is only forwarding.
Yes, forwarding since the order, the original permit was issued by the Mon Additional Deputy Commissioner's office. So the sub-divisional officer deemed it necessary that any order of eviction or whatever should be issued only by the ADC's office. So considering that aspect of the matter, this letter forwarded the petitioner's complaint and with a request to examine the matter and to issue eviction orders of all the illegal encroachers.
So this was published on?
This is, the first one is 1994, 19th March, the letter written by the then sub-divisional officer is 94, 9th March. This is December, Your Lordship, it should be December, this is December 13th, notification the petitioner issued, December 14th of 1995.
Yes. This was on. Yes.
Your Lordship. Now, paragraph 8. Considering the inaction on the part of the district administration to protect the petitioner's rights and interests, petitioner submitted a representation to the Chief Secretary Nagaland to intervene in the matter, and the Chief Secretary Nagaland, White number dated 18/7/1996, made it clear that a special permit to farmland at Dizit was given to late Nocturne Wangshu. Now, I'll take your Lordship straight to the annexure F, page 40. Annexure F. This is the order issued by the then Chief Secretary in 1996. The type copy is at page 42, Your Worship. Page 42 is the type copy. Government of Nagaland, Office of the Chief Secretary. Yes, page 42. Number NGO -1/96, dated 18th July 1996. If I may read, Your Lordship, it is very clear from this letter itself, from this order itself. If I may read, Your Lordship.
Yes.
A representation has been submitted to me by L. Nokman Wangshu, son of late Lokten Wangshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. This special permit for farmland at Dizit was given to late Lokten Wangshu, the then RCM, and the area given to him was properly alienated. In course of time, encroachments had taken place by police department, industry department, and also by private individuals through permits given by administration at different times. The land given to late Lokten Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. It appears that no respect was shown to the permit holder, who was given the farmland by administration for recognition of his services given to the government and the people. Even the Angs of Dizit area had consented to this as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people, instead of protecting the privilege given to certain distinguished persons. If the administration allows encroachment by individuals or government departments, it does not show any good image before the public. You are hereby asked to conduct special inquiry and submit detailed report comments as early as possible. It is very clear, Your Lordship. The special report is only to see the extent of the encroachment and to act upon it. If there has been encroachments, appropriate action to be taken. That is the foundation of the, that is the very object of this letter, order. Now, Your Lordship, still no action was taken by the district administration based on this directive from the Chief Secretary. Now, again, encroachments were going on. So the petitioner submitted representation after representation. So the representation, one representation that is 7/1/2002.
Representation.
One representation to the deputy commissioner. This is 7/1/2002, if I may read. Complaint against encroachment of land belonging to L. Wangshu Konyak, ex-RCM Dizit. Sir, with reference to the subject cited above, I beg to submit the following few lines for your kind information and necessary action. That I am the son of late Wangshu Konyak, ex-RCM Dizit. That certain land was allotted in the name of my late father L. Wangshu Konyak, the then additional deputy commissioner Mon Nagaland, white memo number so and so, dated 29/3/71. And the possessions of the lands were handed over to my late father. The photocopy of the said memo is enclosed herewith for ready reference of your honor. That my father late L. Wangshu Konyak died in the year 1974 while we were minors. That on the death of my father L. Wangshu Konyak, and as we were minors, and so certain lands were encroached by residents as well as by government department. That furthermore, the civil administration has issued residential permits to different residents without giving us any information or any compensation whatsoever. 6, that the matter of encroachment was intimated to the civil administration for several times, but the civil administration paid no heed to it. And so I am compelled to file this complaint once again before your asking proper redress of my grievance. Under the above facts and circumstances, your honor may be kind enough to look into the matter judicially and to cancel the residence by civil administration visit and also to stop further issuance of residence permit immediately to any resident over the land of my late father L. Wangshu Konyak else. I shall be compelled to take shelter of Honorable High Court for proper redress of my grievance. Now, subsequent to this, Your Lordship, Annexure H, page 46. Oh, I'll take Your Lordship to this Annexure L since the details are, the facts regarding this are to be found in paragraph 10 of my petition, the facts pertaining to this particular circular, which is 8 February 05. Paragraph 10.
This is regarding?
The next, there was an attempt to establish a higher secondary school building.
Just 1 minute.
An attempt was made to set up the higher secondary school on the land itself again. So I have given the facts at paragraph 10 that meanwhile, paragraph 10, page 13, Your Lordship, that meanwhile, an attempt was also made to establish the higher secondary school on the petitioner's land without obtaining the consent of the petitioner. The petitioner therefore protested against the said move, and considering the petitioner's objections, the additional deputy commissioner issued circular number so-and-so dated 8/2/2005, whereby a meeting was convened to consider the petitioner's objections. On the date fixed, petitioner presented himself at a meeting with all relevant documents and submitted his case before the authority. However, subsequent to the meeting, no order was passed by the authority. No order was passed? Yes, Your Lordship.
Okay, we'll resume it to.
May I please, Your Lordship?
Yes.
Your Lordship, if I may be allowed to make a mention, Your Lordship.
Mention for what?
For item number 41, Your Lordship.
Okay, item 41.
Lordship.
Yes.
Lordship, here I am paying for respondent number 2 entry, Your Lordship.
Okay.
Your Lordship, consent have been taken from the appellant, Your Lordship, from the opposite party, Your Lordship. If the matter can come up.
Mr. M. Solo,
Lordship.
counsel for the respondent number 2 and 3, with the consent of the learned counsel for the petitioner, pray for listing this matter.
After 3 weeks, Your Lordship.
After 3 weeks, no
Lordship.
prayer is allowed. No, where is he? See, she's not there. I was dictating. It was funny. That was funny. Mm. Item
41, Your Lordship.
41. Mm. Okay, Mr. M. Solo, learned counsel for the respondent number 2 and 3, with the consent of the learned counsel for the petitioner, prays for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Much.
I think if there is any other item other than the one, no, no. Hmm? 38. 38. You have any matter? Which one?
Item 38.
30 will not be, I think this will cover, not be able to take up this matter. Probably, so. So this, I think will cover this matter. So there is a 4 matter, 4. So this we can have in summary day.
So after the lordship,
Yes, 15.
70 cases. So 2030 some other matters of yours. 23rd. Lordship then on 23rd.
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 23rd. That's a Tuesday, coming Tuesday.
Okay, hard Mr.
And can you come
For
for the petition?
We come, not counsel for petitioner and Mr.
Until
Not counsel for the respondent number 3.
respondents, respondent number 3 is.
3, so is grateful by both the Lana counsel for the parties. List this matter on 23rd.
23rd.
Okay, 23rd April. May.
Not April, April month.
April. Okay.
Yes.
Okay.
Good.
Resume 2.
Item 30. Item 30. 23 이때나 itu fixase কিন্তু part hard আছে দেই part hard আছে 19 কইলাবি itu কারণে part hard লিখিব লাগিব এটা কি লিখি দেয় fix part hard আছে part hard আছে part hard আছে itu kita part hard আছে বলে 13 November last year 13 November there November 30 there na last year part hard to last year judgment November 30 there part hard Thank you.
I wanted to do this also. As I do not. I mean, not with the uniform. Uniform person. Familiarity of the law. Designer, we wanted to get. Oh. But looking at you, I really it didn't figure out. Yeah, teaching the conversation, I didn't know to be the
Yes. Yes, your lordship. I'll take your lordship to page 48, annexure I.
Page 48.
Yes, these are representations, some other representations submitted by the petitioner. Because the department, the district administration was making allotments to, even to private individuals for settlement on the land of the petitioner. So petitioner submitted representations. Page 48, annexure I1. So this is dated 2nd March 2012. Subject an application to stop unauthorized allotment of land to different other persons, which lands are in occupation of the undersigned. since it was allotted in the names of the father of Shri Petitioner Wangshu Konyak. Since this is White Special Permit dated 1971, 28 March, issued by ADC Mon, Shri DCK Lota IAS. Respected sir, with due respect and humble submission, that I, the undersigned, would like to let you know that the specific plots of land situated under Dizit Township was allotted in the name of late Wangshu Konyak, since this is White Special Permit dated 29 March 1971, issued by late ADC Mon, Shri DCK Lota IAS, and which was subsequently confirmed by the learned circle officer, Mr. S. Imkong Jamir, White Memo number so-and-so dated 11th April 1975, that your petitioner is the son of late Wangshu Konyak and has been owning, possessing the entire said land exclusively and or specifically. But now it has come to the notice of the undersigned that the administrative authority to visit subdivision under compelling circumstances and pressure of the superior authority is in motion to allot the same land under occupation of the undersigned to and in the name of somebody else. And any such further allotment of the named land will be unauthoritative and which will create law and order situation amongst all those interested persons together with the undersigned. And your petitioner shall have no other alternative but to take the shelter under the law of the land. The copies of such allotment orders referred above are enclosed herewith for your honor's perusal and as Annexure 1 and 2. Under the circumstances, I would like to inform you that to stop all kinds of such allotment of the same land, which is still under occupation of your petitioner derived from his father. Otherwise, I shall have no option but to take the shelter under the law of the land state to restrain such allotment if done in near future. This was 2nd March 2012. Again, this is 17th September, the next page, that is Annexure I2, page 49. These are both letters to the Additional Deputy Commissioner, District Mon, Nagaland. Subject, complaint on issuing of residential site permit within my demarcation location under the special pada so-and-so. Respected sir, I have the honor to lay down these few lines for favor of your high authority to look into the matter at an early date and necessary action, please. Thus, sir, it is learned from persons, etc., are applying for site permit within my allotted location in this town. I therefore request your high authority to stop of issuing permit at present and also in future without my concern, please. For which act of your kind action, I shall remain ever respect to your sir. So these were representations submitted by the petitioner against allotment made by the district administration. And finally, in desperation, the petitioner was compelled to approach this honorable court by preferring a writ petition, which is WPC number 204K of 2012. WPC number 204K 2012. This honorable court disposed of the petition by judgment and order dated 5/8/2014, which is at page 50, Your Lordship. Page 50.
Disposed by saying what? What direction was given here?
Your Lordship, page 52, paragraph 5. This is the operative portion. Para 5, if I may read, Your Lordship.
Yes.
Para 5 and onwards, para 5 onwards. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum on 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right. The Chief Secretary of the State, being aware of the situation, issued direction to the Jurisdictional Deputy Commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold the special inquiry as directed by the Chief Secretary. Although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible, but the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the chief administrator of the state has been stalled. Failure on the part of an authority in complying with direction of its superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic setup of governance. Although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed. The fact as to issuance of direction by the chief secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold special inquiry as was directed by the chief secretary by order dated 18/7/1996, Annexure F, within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the chief secretary for passing necessary orders. The chief secretary shall pass necessary final orders within 2 months. Thereafter, from the date of receipt of inquiry report from the Deputy Commissioner Mon. The petitioner shall forthwith furnish a copy of this order to the Deputy Commissioner Mon and shall get necessary acknowledgement on the body of the forwarding letter. So it is very clear, Your Lordship. It is an undisputed case. The land was allotted to the petitioner's father. If there is encroachment, it is a violation of the petitioner's constitutional rights. So as per the direction of the chief secretary and as per the direction of this honorable court, by this judgment and order, the only thing required to determine is the extent of encroachments that has been done. Who has encroached, which department, who has encroached upon the land, and based on that, appropriate orders is to be passed. It is as simple as that, Your Lordship. The question of cancelling the allotment made to the petitioner's father way back in 1971 does not arise as per this. Now, page 55.
54.
Oh, 50, yes, 54, Your Lordship. This is the special inquiry report submitted by the ADC. Additional Deputy Commissioner. This is
What the report basically says?
the report basically says that starting from page 56, Your Lordship may, regarding the background, the facts are admitted about the allotment of the land. Now, page 56, that is internal page is page 2, Your Lordship.
Yes.
From the second paragraph. On cross-examination of the official records available in the office, this committee concluded that a special permission granted is authentic. However, the extent of the area and boundaries as contained in the special permit issued white memos dated so-and-so 29 March 1971, though properly delineated during the issue of the permit in 1971. The details of boundaries could not be traced by the committee members. But as claimed by the complainant, Nokman, the special permission does not cover the entire area south to Mon, Sonari Road. To get a rough idea of the actual of the land, the committee decided to take a physical verification of the land with the help of retired Tobachi Shri Achoak and Mr. Zanai, caretaker of Mr. Nokman, who were present during April 1975 verification. The physical verification was undertaken on 27/10/2014 with the help of the above named two persons, along with Shri Nokman Wangshu. Even Shri Nokman, during his meeting with the committee on 24/10/2014, admitted that he has no knowledge of the exact boundaries as contained in the permit. The area as shown by Shri Achoak, retired DB, and Shri Zanai, caretaker of Nokman in 1975 was surveyed with the help of GPS by the committee. Enclosed map covers a total area of 157.51 acres of land, which is very much within the Digit Town jurisdiction. On cross-examination of official records on issue of permits, it has been found that in various stages and of officers at Digit, permits were issued by the authority concerned in the name of expansion of the town. to cater to the ever-increasing need of the fast population town government departments, industries, and other public utility was set up by the government purely to meet the increasing need of the town. Digit. All the above government departments, utility services are functioning today at Digit. On physical verification, it has been found that the district administration during various tenures of officers has issued 111 numbers of permits from 1988 till date.
In the same land.
Same land, the same land, they were issuing permits. So not only government departments, only few government departments like industries but all the others are privates, private individuals.
Permit to?
Mostly to private individuals to.
Permit for construction?
Of buildings, buildings on the land. For construction of buildings on the land.
Okay.
And this encroachment was going on. Well, the petitioner has been asking the department not to do it. They are oblivious to the petitioner's pleas. Even the chief secretary has said it is illegal to do this.
So
altogether
111 permits.
Yes.
So permit means allotment or?
Yes, they issue some kind of a permit to particular individuals that you are allowed this area of land on this particular plot.
That is permanent or what?
It is permanent allotment. Permanent allotment, Your Lordship.
Okay.
Next paragraph. During inquiry, it is also found that the complainant, Shri Nokman, on his own capacity, has been selling out plots of land to private individuals at substantial rates without the consent and information to the government. On further inquiry, it is also found that vast tracts of land have already been allotted, given away free of cost to several private individuals on several locations. It has been revealed that Shri Nokman, taking all full advantage of the privilege given by government to his father for a farmland, has sold out plots to 12 identified individuals by taking substantial amount of money and letter permit acquired by these Tonis from the ADC office district. Furthermore, due to his uncompromising stance between government and Nokman, several individuals taking advantage of the situation has been occupying in more than 17 locations plots without any sanction from government. Committee findings. 1. The special permit issued in 1971, White Memo so-and-so, dated Mon, the 29 March 1971, issued by the then ADC Mon is authentic. However, there is no record of payment of revenue to the government, and the permit does not stipulate any terms and conditions governing the special permit. 2. It is an accepted fact that the land for Digit headquarters town was donated by Chapoka village to the government, and the special permit itself was issued to late L. Wangsho by the government. In view of the rapidly growing population of Digit town, the district administration needs more land for development of the town to appease the growing needs of land for dwelling units. The district administration have issued permits for the purpose of expansion and development of the town. 3. There are already 111 numbers of permits issued by district administration from 1988 till date. Further, 12 numbers of plots were settled through the complainant and 17 numbers without any permission.
12 numbers?
12 numbers through the complainant, that is the petitioner. Petitioner has.
Okay, has also.
Yes, but in his case, it is a legitimate one.
So.
And 17 are?
The one issued by the petitioner is also still under occupation.
Yes, because it is the petitioner's land, the petitioner
and they, whether they have subsequently obtained permit from the
government? They have. Since it is a town area, normally when allotments are done or even plots are bought, even here in Kohima, when we buy plots from private individuals, what we do is, in order to protect the land, the district administration also issues pata in this case. So these allotments, patas are issued.
This after 12% given by
the petitioner.
The petitioner.
Yes.
Was subsequently they also obtained permit from the government.
Yes, that is what.
So these 12.
Yes.
There is already 111 the permit issued by the administration till date. Further 12 were settled through the complainant and 17 without any permission. 17 are encroacher.
Yes, encroachers, pure encroachers.
Whether subsequently these 17 also have obtained permission from the government?
No, as per this, they have not.
So altogether it will be 111 plus 12.
Yes.
23, 30, 40.
Yes.
140%.
Yes.
Okay.
Now, paragraph 4, Your Lordship. The committee is of the view that to bring an immediate and amicable settlement to this issue, an alternative arrangement may be offered to Sri Nokman Wangshu by offering him 200 by 300 square feet of land presently occupied by him. And also in recognition of the services rendered by his father, late L. Wangshu, either a school or public hall in the locality be named after him.
So it is for him only 200 to 300
Yes.
feet.
Yes.
Left. 200, 300 feet means
It's a small, it's a small area. It may be about the size of this area only. This office building complex only, Your Lordship.
it is square feet.
Yes.
Square feet.
200/300 square feet. That means land 200 width 300.
Oh, okay. 200.
Land and breadth only. This is breadth and length. Breadth 200 feet, breadth 300
Okay,
feet.
50 by 100 meters says.
Yes.
Okay, around 100.
Yes.
Okay.
Yes. Only that much. And also in recognition of the service, so that is to name one school or
In that area.
in that area in the name of the petitioner's father.
So there are sufficient space left for establishment of schools also.
There are.
Okay.
There are. It is a farmland given to the petitioner's father. So the land was quite big. Now it has, because of this encroachment, it has now reduced to by a very big chunk.
Okay.
Number 5, further, during the course of the inquiry, the Special Inquiry Committee has received a complaint letter from the Village Council Chapoka, which are made available to you in original, as the committee has no legal obligation in replying to this complaint. So this was the overall report which was submitted. So this is the sketch map is at page 59.
Yes.
So prepared by the administration. For us, it is difficult to make out the entire area, but they have given it as 157.81 acres altogether.
Okay.
Now, now that was submitted. This was the initial, that was the first special inquiry report. The findings of the report is that. Now there was.
This submission of a special
Yes, they have
same?
called the petitioner. Subsequent to this, again, petitioner was called to meetings every now and then. They all this, and every time they had a meeting, these reports were submitted, Your Lordship.
Now this 14 November is this submission of the same report
Yes.
which we have just read.
Now, yes, so after this report was submitted, Your Lordship, by the district administration to the Chief Secretary's office, what happened was they had it appears that some directions were given to the district authority to have meetings with the petitioner. So two more meetings were held, Your Lordship, with the petitioner by the district administration.
Where have you stated that one?
Yeah, page 67. This is the one of them, page 67.
No, so this page 64, what is this submission of a special
Your
report?
Lordship, now page 64 is 12 September 2014, headed by additional with 4 other members in regards to Gauhati High Court, Kohima. This is a submission of the first report. 2014, November 2014. So first committee report was submitted by this letter. This was the letter, covering letter for the report.
The report which we have just read.
Yes, the report which we have just read.
Okay. And this
This
is
were,
this is also second,
this is also submission of special
same
report
thing.
by to the additional chief secretary.
This is
one,
that copy.
yeah, this one, yes. This is also,
So page 66
Yes,
is
type
also
copy.
submission of a special inquiry report.
yes.
What is this?
This is to the deputy commissioner, Mon Nagaland, by the additional deputy commissioner again.
So this is
So,
also about the
this
same
should-
report.
Yes, this ought to happen first, your lordship.
Yes,
because-
yes, that is why I'm saying.
Yes, this ought to happen first.
Okay,
2nd September 2015. By this, deputy commissioner was, the report was submitted to the deputy commissioner again. The deputy commissioner in his turn forwarded it to the additional chief secretary and commissioner. Just by 14 November. So the first letter ought to have been the last one. Now,
just a minute. Okay, then
now, meeting subsequent to this, the district administration, the ADC conducted meetings with the petitioner with regard to this thing. And those meeting minutes, the discussions that went on in the meetings and these were also submitted subsequently. So the first one is page 67. This is the signature appears to.
this is annexer.
This is annexure. It should be annexure M, your lordship. It should be annexure page 67. Your lordship, let me read it out.
Not written.
It is annexure M1, M2, M3, and M4 all together. This starting from page 67, 69 is the forwarding letter. M2, M3 is a type copy. No, sorry. Type copy is at page 70 and 72. Then 73 is
69 should have been in the first.
yes.
So regarding this,
Regarding
which
this-
paragraph have you stated?
This
That the
this
committee thereafter meeting was held. with?
Yes, yes.
Which paragraph?
In paragraph, your lordship, paragraph 15, your lordship. Paragraph 15, page 17. Page 17, paragraph 15.
Okay.
Oh,
so this
no,
is
page, I'm sorry, there were two meetings. So paragraph 14 and 15, your lordship. Paragraph 14 and 15, your lordship. Paragraph 14 is with the first meeting.
okay.
If
So,
I may read, your lordship.
Meeting
with the ADC.
So meeting on the basis of
the earlier report, which was
Report.
submitted. They wanted to
Meeting to-
convince me with regard to how to go about in the event of a decision by the administration how it should be done.
So
that
you
meeting-
were also invited for the meeting.
I was invited, Your Worship.
Okay.
So paragraph 14, yeah, if I may read. Paragraph
Okay.
14, page 15. That subsequent to the submission of the special report, the additional Deputy Commissioner Dizit, on the direction of the Deputy Commissioner Mon, invited the petitioner for meetings dated 10/7/2015 and 31/7/2015, with a view to sort out the outstanding issues regarding the allotment of land. And a report of the meeting was submitted to the Deputy Commissioner Mon, white letter number so and so dated 2/9/2015. The report in brief is that the area of land as per GPS measures 157.81 acres, that if the petitioner's demand for release of compensation for all households already settled on the basis of permits issued by the administration is considered, this will create law and order problem in TZ. That the petitioner did not agree to the offer made by the administration to allot him all vacant plots that exist within the surveyed area if he agrees to relinquish his claim over the sites allotted by the administration. That the administration agreed in principle to forward for recognition and renaming the present industry colony to El Wangshu Colony as and when differences are settled. That it was agreed not to issue any fresh permit from both sides until judgment is received from the Gauhati High Court. That the office will look into matter regarding stoppage of all double permit holder trying to enter on the land if any such cases arise. And that both parties agreed to wait for an early and amicable settlement by the Honorable High Court. Actually, the Honorable High Court had disposed of the matter earlier. Mention may be made herein that at the time of the meeting, the WPC 204K of 2012 had already been disposed of by the judgment and order dated 5/8/2014. But at the meeting, the administration and the petitioners had discussed the issue in the mistaken belief that the matter was still pending disposal. So that was the first meeting. That is, now the second one, paragraph 15, that subsequent to the said meetings, the additional Deputy Commissioner Dizit issued 2 restraining orders. Oh, I'm sorry, that was the meeting. There was only one. I had given the typed copy also, Your Lordship. Now, subsequent to this, another report is there, but we will come to it in chronological order, Your Lordship. 15, now, with regard to the 2 read petitions, the other 2 read petitions from paragraph 15 onwards, Your Lordship. Paragraph 15, this is with regard to WPC 207 of 2016. Subsequent to the said meetings, the additional Deputy Commissioner Dizit issued 2 restraining orders, namely restraining order number so and so dated 15/1/2015 and restraining order number so and so dated 12/10/2016, notifying not to carry out any developmental works in the disputed area by any individual or groups until the final settlement of the cases by the Honorable High Court. Later, by vacation order dated 20/10/2016, the additional Deputy Commissioner Dizit directed 7 individuals who are well-wishers and friends of the petitioner to whom the petitioner had allotted some portion of the land to erect temporary houses with a view to enable their children to pursue their studies in Dizit to vacate the land. The petitioner therefore was compelled to prefer a writ petition registered as WPC 207 of 2016, impugning the aforesaid 2 orders. And this Honorable Court, by order dated 7/11/2016, was pleased to direct that the persons whose names are mentioned in the vacation order dated 20/10/2016 should not be disturbed in their peaceful possession of the land until further orders of the court. The WPC 207/2016 is pending disposal presently. So the copy of this is the order passed in the restraining orders are at page 72. And 73, Your Lordship. Restraining 2 restraining orders and the vacation order. Now the vacation order was actually
72 is?
72 is the restraining order. The first restraining order which is imbued in the
Restraining to whom?
Restraining the persons. It's a general restraining order, Your Lordship.
Okay.
It's a general restraining order directing no one not to carry out any developmental works on the land of the petitioner. until the High Court. In connection with the earlier case, Your Lordship, restraining order, the first restraining order is dated 15 January 2015. The second is 12 October 2016. And then subsequent to this, seven.
So no, earlier annexure is page 67 is not M1. This restraining order is M1.
Yes, yes.
So earlier, what is the annexure?
It should be, I'm sorry, L, it should be L. L1.
L earlier L.
L, it should be annexure L only. Annexure L.
66 is L.
Yes, yes. Page 66 onwards to.
Okay.
71.
Okay.
This
Okay.
is annexure L, Your Lordship. Then M1, the first restraining order, general restraining order. Second also, general restraining order, 2016.
Report. So this restraint order was passed basing on the inquiry report.
Not based on the on the basis of the high pendency of the High Court, as per this, on the basis of the Gauhati High Court case, which was by that time already disposed of, Your Lordship.
So without knowing that,
without they were of the
as there was a stay in the High Court order.
Yes, no, the judgment had already been given in that earlier case to conduct an inquiry. Inquiry was conducted, but they were thinking that it was not a final judgment. That was the assumption of the administration.
Okay.
So the administration was assuming that the matter is still pending. This is why in the first meeting report also it proceeded on the assumption that the case is still pending, whereas final judgment had already been passed in the case. So this general order that until final settlement of the case by the Gauhati High Court. Okay. Whereas there was no case pending at that point of time.
So you also did not bring into the notice of this?
The petitioner, he did not. It appears from here. From here.
So then after?
Then after this, 7 individuals.
Just a minute.
These are just temporary dwellings. These were not land sold or handed over to them, but to help these relatives. They are more or less relations of the petitioner.
No, just a minute. Restraint order is 15 January and also 12 October. What is this order? 12 October
2016.
So what is this? This is also restraint.
Restraining order, just a continuation of the first order only. It should be taken as.
Okay.
Then what happened? This vacation order was issued by the Tobashi's court. The head is given as office of the additional deputy commissioner, but the restraining order was issued by the additional deputy commissioner, but this vacation order was issued by the head DB, head Tobashi, to 7 individuals to whom the petitioner has allotted some portions to just erect some rooms for their children to help them in their children's education at visit.
So who are these persons?
These are people known to the petitioner petitioner.
Acha.
Now,
To those whom the petitioner has given from his side.
from his side, yes.
No, you said that they also obtained subsequently.
No,
they
no, no,
also
this is another group. Those which are in the report is another group, your lordship.
Okay, this is.
This is another group.
This was allowed by the petitioner
Petitioner,
subsequently,
yes,
subsequent
yes.
to the those meeting and the
Yes,
report.
yes.
Thereafter also petitioner has exercised his own right.
With regard to this,
seven
with
percent.
regard to this, yes, because it is his land.
Yes.
It is his land.
Hmm.
It is an occupation of his land. So, but it is not a case of selling of this land. It was only to help them construct some rooms because it is a township. Now children are coming from the villages. In order to help these families, the petitioner allotted them some plots so that they can make some temporary constructions for their children to stay for their educational purpose. But it is not a case of permanent allotment.
So it should have been issued by ADC.
No, even the ADC could not have issued it because the.
No, but you see, Dobashi
Yes,
Dobashi
Tobashis
is under
it should have been,
ADC.
yes, it should have been issued by the ADC, not the Tobashis.
No, head GB, head
TB, head TB, head Tobashi.
No. So it was issued in the knowledge of the ADC.
We don't know. It is, but it appears so from the letter itself, from the order itself. But he is a subordinate. He is a subordinate to the ADC.
And he is subordinate to ADC.
Yes, they are Tobashis. These are the.
So it has not been numbered. It doesn't carry any official number.
No official number, your lordship. Only the date.
Whether he has a right?
No.
So
the Tobashis, unless someone files a case and the administrative authority, that is the deputy commissioner or the ADC, endorse the matter to the Tobashis to take up, the Tobashis cannot take up any case. And so this is.
So that means this is illegal order.
This is an illegal order, as it is.
Whether these persons, these 7 persons have challenged this order?
Because since it is a petitioner's land, petitioner has not sold it. Now they are evicting the petition to these people. So they came to demolish it. It is land which the buildings are. It should be.
Now, where have you stated these 7 persons were also allowed by the petitioner?
Yes, here in the paragraph 15 itself. Paragraph 15 itself, I have given. In paragraph 15, I have clearly stated that well-wishers and friends of the petitioner, to whom the petitioner had allotted some portion of land to erect temporary houses with a view to enable their children to pursue their studies in Dizit to Dizit. It's not permanent allotment, your lordship. So these are constructions done by the petitioner himself. It should be taken as. But these persons were directed. That means it is indirectly taking action without intimation to the petitioner.
So this was verbally allowed or by way of writing or executing any?
No execution of anything.
Just
allowed. Yes, because it is his land. He permitted them to some temporary thatch houses, your lordship, just for their children's educational purposes to stay there.
How long they were staying there? How long they have been occupying that land?
No, the constructions were going on.
Okay.
When this order was issued.
They were evicted.
Yeah. the restraining order was issued, no, not
No,
restraining.
vacate
Vacation order was
order.
issued, but, so the petitioner approached his honorable court,
Okay, against that.
impugning, yes, impugning these three, the first
So
two
on behalf
restraining
of this,
orders.
on behalf of this 7 person.
Yeah, not on behalf, but on behalf of himself, yes, and on behalf of the 7 persons, because he is the actual person who is allowing them to stay there.
So what was the decision? What was the order?
The order, the interim order is this impugn orders are safe, Your Lordship, your page 75. M4, page 75.
Yes.
Your Lordship, the last paragraph, considering the fact that there is no dispute on the ownership of the land and the submission of the learned counsel that the persons whose names are mentioned in the vacation order dated 2016 are persons he allowed to live temporarily on his land, they should not be disturbed in their peaceful possession of the land until further orders of this court.
Considering the fact that there is no dispute on the ownership of the land and submission of the land council of the person whose name are mentioned in the So what happened thereafter?
No, the matter was pending. It's still pending now.
This matter?
Yes, this matter is the 207. 207 of 2016, the first writ petition, Your Lordship.
Okay.
The first writ petition. But the crux of the case is simple. The 2 restraining orders and the last vacation order are the impugn orders in this petition. 207.
Okay.
Now, Your Lordship, again, subsequently again, page 76, Your Lordship, N1. This is with regard to the next case, that is 58K of 2017, Your Lordship. These are the impugned orders.
So that means the case with regards to this 207 is up to date.
Yes. This is
Okay, whether they file they file any objection to this affidavit against
affidavit has not been filed in this case, but the government has come
207 not
forward
filed.
saying that since
Okay.
since it covers the
Okay.
present case, the present 88.
So this was filed in the year 2016 and
Yes,
this present one is filed in the year
2022, Your Lordship.
Okay.
22. But this encapsulates the holding.
Okay.
This case covers the holding. So the government has also rightly pointed out that we don't need to contest in the earlier two cases.
Right.
But in the final
But that,
case on
that was in
filed
the year 2016.
Yes.
So this was in the year filed in the year.
Yes, 2016.
And this
and the second one was in 2017. This, and it is still which involves the private respondent.
Okay. And then this was filed in the year.
The present case is filed in 2022. 22.
So 16.
Yes.
From 16 to 22 is 6 years. 6 years they did
Yes.
not file any affidavit.
They have not.
Okay. So this is what order is this? Page 76.
76 is again with regard to the next case, that is 58. 58 of 2017. The other writ petition. There are,
What is this?
this writ petition is at, this writ petition is item 28, I think.
Reference to the complaint.
Oh, the item 27, yes. Yes. Item 27 is the next case. WPC 58 of 2017. So this annexure N1.
Produce site permit, just a minute. What order is this?
This is also issued by the head Tobashi, your lordship.
So against what? For what?
If your lordship will see here, with reference to a complaint letter, it appears that a complaint letter was written by the private respondents, that is the Monian Union.
Complaint against?
Against one Mr. Wangtun Konyak of Nitong village, to whom he is a missionary, this fellow. Now this person is also staying on that land, on a plot, on the permission, with the permission of the petitioner. He is a missionary. It's a temporary.
Apart from these 7 person.
Yes.
So this missionary
Yes.
was also allotted or
He is also
permitted by
staying.
the
Yes, but
petitioner.
yes, his construction is only a temporary attached building only.
That is subsequent to this 7 person.
Yes, yes. Now this.
Where is
person
that?
a
Have you
different
annexed that?
So this order, yes, after this order was issued by the head TV against this.
No, again, where is the complaint?
We do not know we were not, I was not given any complaint, but from the order itself. From the order itself, your lordship, see.
With reference to
a complaint letter.
let us read.
With reference to a complaint letter dated 23/3/2017 received from Monian Union, that is a private respondent, down against Mr. Wangtun Konyak of Nidong village. There is a person, the missionary to whom the petitioner has allotted a small portion for construction of house at allotted site of Monian Union, Tizit town. In this connection, the DB's court Tizit summoned both parties to appear before the DB's court along with site permits on 13 April 2017. The Monian Tizit town produced site permit, white number so and so, whereas Mr. Wangtun Konyak could not produce a site permit. Site permit was issued by the district administration to the private respondent, which is also illegal per se, your lordship. Now, therefore, the TV's court to hereby direct Mr. Wangtun Konyak of Nidong village to vacate the house and remove the materials from the said site, land on or before 13 May 2017, that is within 1 month from the date of issue of this order. This is,
Against this, you file again.
Yes.
Another writ petition.
The writ petition, that is 58K of 2017.
Just a minute. Okay, so
they did.
Just a minute.
Yes.
Where have you stated now?
In the petition, page 18, paragraph 16.
Writ petition number, this is
58.
58.
58.
2017.
2017. 58K. Earlier, we used to number it as 58 under brackets K. That means Kohima of 2017. So it is that.
Just a minute. So this is also pending.
Yes, this is also pending. The stay order is page 77. The interim order.
You have stated about this in paragraph?
Paragraph 16.
16. Let us just see once what you have stated in 16.
It is in very brief terms, Your Lordship. That again, since the writ petition is already there. That again, paragraph 16, page 18. The Monian Union Tizit, having filed a case before the Tobashi's court, TZ claiming as theirs a plot of land which the petitioner had allotted to one Mr. Wang Dun, a missionary. The TB's court by order dated 13/4/2017 directed Mr. Wang Dun to vacate the land. The petitioner therefore preferred another writ petition registered as WPC 58K of 2017, impugning the order dated 13/4/2017, and the Honorable Court by order dated 9/5/2017 was pleased to suspend the said order. The WPC 58K 2017 is also pending disposal.
Any stay over there?
Yes, the stay order is
Okay.
page 77, Your Lordship. Page 77. Annexure N2. This order is dated 9/5/2017.
Okay. Okay, that.
Yes, Your Lordship. Now,
So this is 58. Yes, so 2007, then 58. Okay, yes. Yes. So here,
yes,
58, the also private respondent.
yes.
You mean, okay. So this, what do we call, what is this? Private respondent is
It is a union.
union,
Yes.
not an individual person.
No.
What union is this?
Comprises of cluster of villages.
Of this area?
Around the district.
No, this village means village within the area of the claimed petitioner's land. Okay. So now these are the person who are within the, among these 111 persons.
Yes. Yes.
Okay, so this has been established as a village.
That it's a no, it is a town, and
It's a
then
town.
in the low-lying areas or outskirts of the town, the land was allotted to the petitioners further. So now all these encroachments are being done.
This encroacher has become a villager of what
No,
is
no,
this?
it is not a village. It is still part of the town, Your Lordship. Is it town? They are. It is not a separate village.
Okay.
They just
They are union.
Yes, the union is claiming this particular plot.
No, union only, this union, members of the union are among these 111 persons only.
No.
Others also.
Others, individuals.
They come from different villages
Yes.
nearby that particular plot of land.
Okay.
And they form a union and they are residing here in that town. Otherwise, they come from different villages.
So how they are agreed by this allotment of land by the owner of the land to another, say, missionary, how they are agreed?
Lordship, because the same plot of land that was allotted to the missionary
Huh.
was allotted to the union, to the
By?
respondent number 6 by the government, Lordship.
By the government.
Having proper
Okay.
documents of
Okay. So union means it's not an individual person.
No, Lordship.
So how much of area has been allotted?
80 by 80, Lordship.
80 by 80. So according to you, the lane allotted by the petitioner is within the 80 by 80
Yes.
Lordship.
area being allotted by the government to the union.
Lordship.
So that is why you objected.
Lordship.
File Dobasi, file before the Dobasi, and then Dobasi declared in your favor.
Dispose of the matter on placing on record of my partner, Lordship.
Okay.
Lordship.
So you have a proper pata.
Lordship.
Okay. Okay, thank you.
Yes, Your Lordship. Now, pending these cases, and since all the reports had already been submitted, but no action being taken, the petitioner submitted a representation which is in the page 78. This is for praying for settlement of land dispute. laying down all the facts, Your Lordship. Earlier facts, how things happened.
So you have submitted representation before that?
Yes, before the Chief Secretary, Nagaland, Chief Secretary.
Okay.
Now,
uh, praying for what?
Praying for settlement, final settlement, because no, the Chief Secretary was supposed to get the report of the committee with regard to the position of the land. And the Chief Secretary, as per the direction of this Honorable Court in the first case, that is 204.
Okay, so you submitted representation?
Yes, representation
before the
for
Chief
early
Secretary?
submission. Yes.
Requesting for settlement of
Yes,
the
of
matter.
that matter, yes. Since report has already been.
And then at that
submitted.
time, writ petition number 207 and 58 were still pending.
Yes, they were still pending and.
And in the 207 also you have a stay order?
Yes, in both there are.
In both.
Stay
Have
orders.
you annexed the stay order in the 207 also?
Yes, yes, it is here. In 207, page 75, Your Lordship.
Okay, no.
In this 80,
Okay,
yes,
okay,
in this
fine.
88 also stay order
Fine,
is
fine.
there.
So, no, just a minute.
In both the cases, I have annexed this Honorable Court's interim orders.
Okay. Okay, yes. Then, so what happened?
So now the Chief Secretary was supposed to take a decision on the report, inquiry report.
Okay, so
As per
your
that,
prayer was also
Yes.
to take a decision on the inquiry
Yes,
report
yes,
also?
yes.
Okay.
To make a settlement on the basis, this is 5/3/2019.
Yes.
The Chief Secretary was sitting over the matter.
So what did thereafter the Chief Secretary do?
Now, the first impugned order is at page 80, Your Lordship, Annexure B. Now, no order was passed by the Chief Secretary. The Chief Secretary was to take the decision, whereas the decision was taken at the Home Commissioner level. Home Department. So the first impugned order is this one. This is 24th September 2018.
So this is, let us read the order.
Yes, Your Order. In pursuance to the letter from the Home Department, Government of Nagaland, White, letter number GAB 14, Court 167, 2017, dated Kohima, the 14th September 2017. With regard to special inquiry report on the special permit issued to late Wangshu Konyak for farmland at Digit headquarters, the permit number so and so dated 29/3/1971 is hereby cancelled with immediate effect in view of the expansion and development of Digit administrative headquarters, requiring all vacant land for public office establishment.
So,
so this was issued by the Deputy Commissioner.
So this is just suddenly, so you have
Yes,
submitted this.
when I was not aware.
Just a minute,
Yes.
you submitted representation.
Representation only in 2019.
19 only,
Yes.
19 March.
Yes.
So this was in the September.
Yes.
So before issuing of this order.
Yeah, this
whether
had
any
already come
notice-
out.
Whether any notice was issued to you?
No notice, Your Worship. No notice. This order was issued just like this. And then the basis.
So the allotment order, white order, the order number is correctly mentioned here, by which you were allowed
Whether,
Yes, farmland at DZ headquarter permit number eight four
okay,
eight
this is
seven.
correctly mentioned.
Yes, it is
Okay,
correctly
this is
mentioned.
yours.
Date is also, yes, date is also correct. 29/3/1971.
So cancelled it.
It is, the deputy commissioner straight
So,
away cancelled it. Now,
referred any number, just a minute, huh?
yes,
Referred any letter, number of earlier.
yes, they are, it is, the TC is mentioning to one letter from the home department, which is dated 14 September 2017.
Yes, where is this?
This is not there, your lordship, but this is the one, the next page. This is January 2020,
Just
your
a
lordship.
minute, just a minute, huh? Who passed this order? Deputy Commissioner.
Deputy Commissioner of Mon.
Who allotted this land earlier?
Allotment was allotted by the, at that point of time, additional deputy commissioner.
Additional
Yes,
allotment, of additional deputy commissioner.
yes, at that point of time, it was
Okay,
the
okay.
additional deputy commissioner.
So your initial allotment was by the of Moon district.
Yes,
Okay,
Additional
but
deputy
now this
commissioner.
is cancelled by deputy commissioner.
yes, yes.
Okay, otherwise it's fine. Just a minute, huh? Okay, so
Now, your
then-
lordship, something fishy is here, your lordship. The real order directing for cancellation of the order, the cancellation of the permit is to be found in this at page 81, annexure Q, which is 25th January 2020, your lordship. 25th January 2020.
25, who, this was
It
issued by
was
whom?
issued by the Home Commissioner, your lordship. Principal Secretary.
No,
Home.
this was after
After
the
the,
issuance of this cancellation order.
yes, your lordship.
So they have second time cancellation.
Your lordship, no mention is made about this, either this one or that particular letter which is mentioned on regarding 14 September 2017 issued by the.
So here also they have mentioned about the letter of this 14 September. Where?
No, so your lordship, if I may read this here, it will make it clear. This
Okay,
page 81.
okay, please, let us.
Yes, page 81. To the Deputy Commissioner, Mon, Nagaland, this is dated 25th January 2020, Home Department. Sir, regarding special permit for farmland at DZ dated so and so to late Shri Wangshu Konya. Sir, please refer to the subject cited above and the letter number judicial LR 1/2019/20 dated 1st February 2020 from ADC DZ addressed to you with regard to the status of the entire land under the special permit as it existed on date copy enclosed and another letter number judicial land so and so number dated 8th of January 2020 from ADC DZ addressed to you mentioning the meetings with Sri L. Nokman Wangshu Konyak for settlement of the entire dispute concerning the aforesaid land copy enclosed. That number 2, the detailed report of.
So just a minute. This referred, he is referring to this letter cited.
Yes.
28th February. So he is referring 1st February, which one?
That is those meetings that were conducted and submitted to the Home Commissioner.
Okay,
Yes,
so
to
he's
the,
referring, okay.
yes, to the Chief Secretary.
And another letter,
Yeah.
and then what about this
Number
8th January is
judicial
also?
dated 8th of January 2020 from ADC DZ addressed to you.
No, what letter is this?
Your lordship. No, these letters are not here, your lordship. We don't know what went on between them.
So you do not know what letter they are referring to?
Yes, what letter they are referring to. The earlier letters were 2015 and 16, I'm sorry. 2015 only.
So you are not
So
aware of this
we are-
letter 8 January 2020?
Yes, I'm not aware. I am not aware.
Okay.
I am
so,
only aware of these two two letters. These are the effective ones.
Okay. Okay,
Now,
so from ADC, they said it's from ADC.
Yes, from the ADC, So it's at a lower level,
Okay,
lower levels.
so let us come to the next para.
Now, next paragraph, the detailed report
So
of,
copy enclosed, have you obtained a copy?
no, this,
No. Okay,
these are, no, that is, no copies are here enclosed.
okay,
The petitioner was given only this.
okay,
Number two, the detailed report of ATC visit of the land under the special report show that out of the 157.81 acres of land initially, Sri L. Lokman Konyak has over the decades sold given 94.195 acres of land to various individuals, organizations, which is about 60% of the total land. The area of the land which is allotted to private individuals, organizations by the officers of ADC visit is 42,400 and 42,4314 acres. 42.43 acres. The land utilized for government department offices and for roads and other public utilities like drains is just 16.928 acres. The report also mentions that after survey, the land under actual possession of Sri L. Nokman Wangshu, his residence and fishery bond is 0.67 acres and not 5.1 acres as reported earlier. The report states that the vacant land behind the house of Sri L. Nokman Wangshu Konyak, which was allotted to 12 private individuals by ADC Dizit in 2012, and which is being asked now by Sri L. Nokman Wangshu Konyak for settlement, covers an area of 4.43 acres. 3. It is thus clear that Sri L. Nokman Wangshu Konyak has over the years already disposed of a substantial portion of the land under the special permit, which was given to his late father for cultivation purposes only, for giving, selling to many private individuals, organizations without any intimation or consent of the government. Hence, it will not be proper to consider allotting any more land to Sri L. Nokman Konyak. The ADC
and Lokman Konyak is the petitioner.
is a petitioner.
Yes.
The ADC Dizit may accordingly be asked to convey the same to Sri L. Nokman Konyak. 4. As recommended in the special inquiry report of 2014 by a committee headed by ADC Dizit, you may make allotment to Sri L. Nokman Konyak only for the land measuring 0.67 acres, which is under his actual possession. Further, as also recommended in recognition of the services rendered by the late father of Sri L. Nokman Konyak, ADC Dizit may be asked to take concrete steps in the direction of getting a school or public hall in the locality named after late Sri L. Wangshu Konyak. Further, in public interest and taking into account the present circumstances as it exists in Dizit town, all the vacant plots, tracts of land falling under the special permit need to be kept for use by any government office or for taking up any developmental activity that may come up in future. Hence, you may take immediate steps for cancelling the allotments covering an area of 4.43 acres to 12 private individuals made by ADC DZ in the year 2012, which is a consolidated tract of land at one place and mentioned at serial number 44 in the report of ADC DZ dated 1st of February 2020, and take under the custody of the government. The vacant plots not sold given to private individuals by Sri L. Nokman Wangshu Konyak or allotted through any permit by ADC Dizit, as well as those plots sold given to private individuals by Sri L. Nokman Wangshu Konyak, but vacant mentioned at serial number 10 and 8 in the report of ADC Dizit dated 1st of February 2020, which measures 7.674 acres, so and so, may also be taken over by the government. In all these cases, proper allotment orders in a manner as considered appropriate by you may be made, so that there is absolute clarity and these tracts of land belong to government. 7. As regards the land already allotted to private individuals by Sri L. Nokman Wangshu Konyak and which are not vacant, with some constructions done or some development of the land done in some manner, and for which permits have not been given by ADC Dizit, as mentioned at serial number 6 of the detailed report from ADC Dizit. That is so and so, you may prepare a proposal and submit to this office for regularizing such allotments by giving permits issued by ADC Dizit. Action on similar lines may also be taken for an area of land so acres, which is not vacant and over the years have got occupied by private individuals, organizations without being allotted by ATC TZ or being sold, given by Sri L. Nokman Wangsu Konya, as mentioned at serial number 9 of report dated so and so. You may take immediate steps to take action on all the points.
Where is that? Where is?
Your Lordship.
Where is the next page?
Next page is page 83 is missing. Page 83, Your Lordship.
No, 83 is something else.
Oh, Your Lordship.
83 is letter to the home.
Oh, could it be next page? If Your Lordship may go to the next page, if that is the last small paragraph. Could it?
Where do we?
In our.
It's not there.
Let me take the second copy of it. The second copy is like that. Maybe something went wrong.
Okay, so yes, you have, you see, this after 82, it is, I think, 83 is something else, and 84 again, I think, is the continuation of this 82.
Oh,
83 is something else.
It was a mistake on our part, Your Lordship.
Hmm.
I apologize for that.
Okay,
Yes.
okay, this is prayer.
Yes.
Immediate steps.
So this was issued by the Principal Secretary, Home, not the Chief Secretary, Your Lordship. As per the direction of this Honorable Court.
Now, this letter, it appears that this was issued on 25th January 2020.
Yes.
But then your letter, your land has already been cancelled.
Yes, by the Deputy
2018.
Commissioner. Something is wrong with the things going on in the department and subsequent developments. Since all these letters which are mentioned in the with regard to letters
So,
issued by
anything
ATC,
happened in between this 2018 and 2020?
no, despite this order, the government did not take any action. Despite this 2018 order, no action, because this was only subsequently given after this, Your Lordship, to the petitioner, but no action has been taken. Nothing.
Okay.
No action. So subsequent to this, the petitioner submitted a representation again.
Okay, this representation was submitted on?
This was stated 10/3/2021. 10/3/2021.
Is the last representation?
Yes, last representation by the.
Just a minute, huh? So. Annex. So now this Q was issued by Principal Secretary.
Yes, Principal Secretary, Home.
Letter to Deputy Commissioner, DC Mon.
Yes, letter to the DC Mon.
So this is basically to cancel.
You have to cancel the whole thing. Only that which is presently occupied by the petitioner is to be given to the petitioner, a town hall or whatever, a school, whatever is to be named as in honor of the petitioner's father. Basically, everything is to be taken away from the petitioner.
And what about the land given to his friends and his friends by the petitioner?
Everything is to be taken away. Only the petition,
Okay, only his actual possession.
only possession.
Okay.
That is
So-
the only one which is to be given to the petitioner.
Mhm. Not 83. Okay, 83. No. This is Q. Q is 81. So this is your last
Yes, this
representation?
is the last representation. I have highlighted all the events, Your Lordship, important events. That as per the permit, it is a permanent permit. The permit itself is a permanent one, Your Lordship. The district administration has been acknowledging its permanent nature. It has been going on. Even the chief secretary has made it clear in his letter to the deputy commissioner that commitments given by previous administration should be upheld. And that if there are encroachments, it is illegal. So a special report be prepared and submitted to me.
Where was that letter, Chief Secretary? That was annexure?
Annexure C, page 35, 34 and 35. No, I'm sorry, page I'm sorry, Your Lordship. Page 40, annexure F. Page 42 is the typed copy.
No, where?
Page 40.
Details. So this is only to for submission of report?
Yes, but Your Lordship, if this honorable court will read the whole thing, representation, I will.
Where do we find the sentence that the commitment is to be respected?
The second paragraph, Your Lordship. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people, instead of protecting the privilege given to certain distinguished persons. If the administration allows encroachment by individuals or government departments, it does not show any good image before the public. You are hereby asked to conduct special inquiry and submit detailed report comments as early as possible. So from here, it is very clear. What is the extent of the encroachment? Submit report immediately so that appropriate action will be taken, because it cannot be done. These kind of encroachments cannot be allowed. That is the Chief Secretary's order. And this Honorable High Court's order, this Honorable Court's order in the
Okay, so then
petition is also very clear.
yes,
His
so-
constitutional rights cannot be taken away.
And in your last representation,
All this has been highlighted, Your Lordship.
okay, and so what prayer you have made?
So we have made for, the prayer is, therefore, in view of the above facts and circumstances and in the interest of justice, the impugned arbitrary order stated 24/9/2018 and 25/2/2020 be quashed and set aside forthwith, and award appropriate rate of compensation to the applicant petitioner for taking over my land without my consent by way of establishing government offices, besides illegally issuing land permits to many individuals and organizations behind my back. Therefore, taking into consideration the aforementioned facts and circumstances in its entirety, the applicant petitioner hereby appeal to your competent authority to kindly settle the matter amicably once and for all with application of judicious mind. So the petitioner has laid out all the facts.
So the
Judgment-
petitioner also praying for compensation.
Yes, compensation of those illegal allotments already made. And that is that which is now occupied, which remains unallotted, not allotted, should not be touched. That is the basic case of the petitioner.
So there are still some land
There are
which is not
vacant
yet
land.
touched.
It has not
Vacant
been
lands
touched.
still are
Yes,
there.
vacant lands are there.
That is not under your possession.
It is under my possession even now, today. The only thing is that the government has been issuing allotments and these people just crash onto the land and they start here claiming that the government has already allotted them the land.
Okay, so thereafter, this was in the year 2021.
Yes. So since no action was taken on the petitioner's representation, the petitioner was compelled to approach this honorable court by way of this instant writ petition.
Anything else?
No, Your Lordship, my submissions, Your Lordship, I'll just show some specific paragraphs.
What paragraphs?
Your Lordship, I'll take your paragraph 22 onwards, Your Lordship. In paragraph 21 onwards. Page 22.
Yes.
That an impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 on the face of it are patently arbitrary and unsustainable. This honorable court, by the judgment and order dated 5/8/2014, has clearly concluded that the claim of the petitioner regarding the special permit granted to the petitioner's father has not been disputed, and that the issuance of the order to the district administration by the chief secretary is also not disputed, and accordingly directed the deputy commissioner Mon to conduct special inquiry as directed by the chief secretary by the order dated 18/7/1996, and to submit the report before the chief secretary for appropriate order. The order of the chief secretary dated 18/7/1996 is very clear that the administration had given the land to the petitioner's father in recognition of the assistance rendered by him to the administration, and also for standing for the people in times of difficulty, and that without his or his successor's consent, no land should have been allotted to any person or government departments. The chief secretary also clearly enunciated that the administration should always honor the commitment given by previous administration to keep its image in the eye of the people. The impugned order dated 24/9/2018 and the impugned order letter dated 25/1/2020 are completely contrary to the order dated 18/7/1996 and the judgment and order dated 5/8/2014. From the judgment and order dated 5/8/2014, it is also obvious that this honorable court had directed the state respondents to take appropriate action to protect the rights of the petitioner and not to violate it. The issue involved in the matter was whether the petitioner's complaint that the administration was illegally issuing allotment in the land granted to the petitioner's father is true or not, and if true, to take remedial action on the matter. Therefore, the state respondents could not cancel the special permit under the facts and circumstances of the case. As such, the impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 are liable to be quashed and set aside. 22. That a special permit dated 29/3/1971 issued to the petitioner's father is a permanent land grant and cannot be cancelled at the whims and fancies of the state respondents. If the state has need of any portion of the land, it may do so by acquiring it under the relevant provisions of law. Otherwise, the state cannot cancel the permit or take forceful occupation of the same anytime it desires. Also, the state has no authority to issue allotments against the land in question. The special inquiry report having arrived at the finding that the administration had issued 111 numbers of permits from 1988 till date to settlers on the petitioner's land, it was therefore incumbent upon the state respondents to award reasonable compensation to the petitioner, commensurate with the area of land allotted by the administration in accordance with the provisions of the existing Land Acquisition Act. Hence, The impugned special inquiry report dated 31/10/2014. The impugned order dated 24/9/2018 and the impugned letter dated 25/1/2020 are liable to be quashed and set aside, and the state respondents directed to pay the petitioner compensation for the land taken over by the administration. 23. That the impugned special inquiry report dated 31/1/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 are unjustifiable, utterly arbitrary and unreasonable, and in clear violation of the petitioner's right to life. Naming a school or public hall in the name of the petitioner's father will not fit the petitioner's family. By cancelling the special permit, the state respondents in one fell swoop has taken away the only means of livelihood for the petitioner and his family. The state action being clearly in violation of the petitioner's fundamental rights to life. The impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated are unsustainable and liable to be quashed and set aside. That when the judgment and order dated 5/8/2014 in the WPC 204K of 2012 specifically directs that upon receipt of the special inquiry report of the Deputy Commissioner Mon, the Chief Secretary shall pass necessary final orders within 2 months. The Chief Secretary could not have delegated the duty imposed upon him by the Honorable Court to the Principal Secretary Home, Nagaland, and the Deputy Commissioner Mon, as had been done in the instant case. The Chief Secretary and no other can pass a final order in the light of the Honorable Court order. The instant case is a classic case of application of power. The impugned order dated 24/9/2018 issued by the Deputy Commissioner Mon, and the impugned letter dated 25/1/2020 issued by the Principal Secretary Home being issued by unauthorized officials are void ab initio and liable to be quashed and set aside as such. That So these are the submissions I have given already, and the following are also my submissions.
Yes.
The main case is they cannot take away the property unless with the authority of law. Law has not been followed in this case, just arbitrarily passing orders, taking away the land. So my humble submission is that the impugned orders as have been laid out in my prayer.
Yeah, okay. You are also relying on any.
Your Lordship, I am not relying on because it is a clear arbitrary, Your Lordship. Arbitrary. Your Lordship.
Okay, yes. Okay. Yes.
May I please, my lord?
Yes.
Lordship, with due submission to my learned senior friends here, from the submission he makes, it appears like the state respondent myself is the most satanic people in the world. However, Your Lordship, that is not so. I would like to, Lordship, open my submission by stating that as my lord has already gone through the entirety of the 3 writ petitions. Writ petition the 207th of 2016 and writ petition also 58 of 2017. What orders has been impugned there, and what is the prayer made by the petitioners there? Your Lordship has already gone into it, and therefore, Your Lordship, to save time, I will not go into that. Okay. However, since my learned senior friends has rightly pointed out that the main crux of the case actually lies in WPC 88, and therefore I will base my submission on this WPC 88 of 2022, Your Lordship. First of all, Your Lordship, in order to claim, or to even say that a person is a landowner, in order to even say that the person is a landowner, he has to establish his right, showing that how he is the landowner.
Yes.
Is it that land which he is claiming to be a landowner is an inherited land? A land that he has purchased it? Or by virtue of what? He is the owner of the land. Now the disputed land in question, Your Lordship, how the petitioner is claiming to be the owner of the land, the petitioner has already read it out. But at the course of repetition, if my Lord will allow me to read the special permit again,
yes,
because this is the basis on how the petitioner is claiming that he is the owner of the land. So if I may be allowed to read the special permit at page 31. of the writ petition, my lord. Page 31 of the writ petition, your lordship.
Yes.
Now it starts with, your lordship, special permit for farmland. For farmland at digit. So the permit is for the purpose of farmland at digit. And it starts with the body 3, L. Wangshu Konat, RCM is allowed to continue cultivation. To continue cultivation of the low-lying areas which has already put under paddy cultivation at digit. The line of the demarcation will be as follows. So this special permit was granted for what purpose, my lord? In the permit itself, it's very clearly mentioned. 3L Wangshu Konyak RCM is allowed to continue cultivation. Let us read the para one. A straight line will be drawn from a point on Sonari Moon Road as shown in the survey map till it joins another survey mark near the private tracks as shown in the survey map. From the survey map point, it will run straight south till the line reaches the first line of banana trees, after which it will fall straight northwest till it comes parallel to the point marked on the stamp by me on 24/5/71. Taking the last point of northwest line, a straight line should be drawn towards south, crossing the marked stem till it reaches another mark on the dead tree. From this dead tree, a line will continue straight for a few yards, then turn southeast and join the now dreamland. Following the area already June this year, a line should join Digit River near the pool called Chizak. Your Lordship, the next line is important. Besides this area, he is also allowed to continue paddy cultivation. Continue paddy cultivation at the confluence of Digit and being shown in the map. Lordship, the last line. Besides these two areas that is mentioned in the special permit, it says, besides these two areas, he shall vacate all the areas he has put under cultivation immediately. So the special permit was granted for what purpose, Your Lordship? For the purpose of cultivation, not for anything else. The permit itself clearly says, the last para, besides these two areas, he shall vacate all the areas he has put under cultivation immediately. The plot of land was never allotted to the petitioner's deceased father through the special permit, because the special permit was only for the purpose of cultivation for farmland, nothing else, Your Lordship. Now, after obtaining this, Your Lordship, what happened is, as my learned friends have said, he started claiming that he is the owner to this plot of land that has been given to his father for cultivation purpose. And he says that his land has been encroached. And therefore, he submitted a representation to the Chief Secretary, which my learned friends has already pointed out. The Chief Secretary of the state, the then Chief Secretary of the state, has directed the Deputy Commissioner to prepare a report and submit, Your Lordship. Thereafter, since that was not done, the petitioner were here before this court by filing WPC 204 of 2012. If I may be allowed to read only the relevant part of the order dated 5/8/2014, whereby this Honorable Court has disposed of this writ petition WPC 204K of 2012. Lordship, the order is at page 50 of the writ petition.
Page 50.
Page 50, 50, my lord.
What is this order?
of the writ
Yes,
petition.
court order, yes.
Yes. Your Lordship, the relevant para at page 52, para 6. If I may be allowed to read, my lord.
Yes.
Although an affidavit opposition has been filed on behalf of the official respondent, the claim of the petitioner has not been disputed. The fact that as to the issuance of the direction by the Chief Secretary is also not disputed. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold a special inquiry, as was directed by the Chief Secretary by order dated 18/7/1996, within a period of 3 months from the date of receipt of a certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of the inquiry report from the Deputy Commissioner Mond. Now, in compliance to this order passed, Your Lordship, a special inquiry committee was constituted. And this inquiry committee was headed by the additional Deputy Commissioner Tijit as the chairman.
Yes.
Lordship will find the the report at page 54. Special inquiry report at page 55, if I may be allowed to read the constitution of the committee. That is the first para. The Special Inquiry Committee was constituted by DC Mont number, Judicial such and such, dated 12/9/2014, in pursuance of the Honorable High Court Kohima Bench judgment and order dated 5/8/2014, WPC 204K of 2012. The Special Inquiry Committee comprises of the following members. 1, ADC Tijit, he is the chairman. So making the additional Deputy Commissioner Tijit as the chairman, the Special Inquiry Committee was constituted by the Deputy Commissioner as directed by this Honorable Court. Now in this committee, the findings, if you see the backgrounds at page 56, the next page, Your Lordship, in the background, it says, as a background to the case, it is to be noted, Your Lordship, this is important. As a background to the case, it is to be noted that the land for Tijit Township was donated by the Japuka village, measuring 1,200 acres. The donation was made to the government, Your Lordship. The donation was made to the government by the villagers free of cost, without any terms and conditions, which was agreed verbally. This farmland also falls within the area donated by the Jaboka villagers. So the area or the plot of land that the government allowed the petitioner's deceased father to cultivate falls within the area of 1,200 acres, which was donated by the Jaboka village to the government for the establishment of Tijit town. It falls under that area. It's clearly mentioned. So the land originally belongs to the Jaboka villagers who have donated the land to the government. From the day the land was donated to the government, the land belongs to the government now. So the land is in possession of the government, Your Lordship. From the day that the land was donated to us, we are in possession of the government of that land, Your Lordship. And since we are in possession of that land, we have the authority. And by using our authority, we have issued the special permit to the petitioner's deceased father to cultivate.
We hold the position, your lordship, from the day the land was donated to us,
Donated to us means?
to the government.
No, then you have read the earlier notification, earlier order given to the petitioner to cultivate, allowing him to cultivate.
Yes.
What about that?
No, that plot of land which was allowed to the petitioners to cultivate is within this area that was donated by the Jaboka villagers to the government.
After donation only you have given.
Yes, because we are in possession of the land. So we own the land now.
Yes.
Therefore, by using that authority and the ownership, we have given the special permit to the petitioner's father to cultivate a portion of the land, which now he is claiming to be the landowner.
No, the portion of land given to the petitioner was the portion of, was also a portion of land that was donated by the villagers to the government.
Correct. It was from that portion of the land.
Was given to the petitioner.
Yes.
Yes.
Was not given to the petitioner, but petitioner's father was allowed to cultivate through the special permit.
Yes.
It was never given or allotted.
Yes.
So in the inquiry report also it is clearly mentioned that it is, see, your lordship, this farmland also falls within the area donated by the Jaboka village.
Report.
Yes. Which clearly shows, your lordship, the owner of that land is the government. And because we are the owner of the land.
Yes, yes. That is why the government is given.
Yes. Not in the form of an allotment, but in the form of a permission to cultivate.
To what extent?
To the extent that the area is mentioned in the map. Only for cultivation purpose. The permit itself is very clear, your lordship.
For how long?
Your lordship, I'll come to that. For how long can the permit exist?
Okay.
I'll come at the later stage of my submission, your lordship. Now, your lordship, the committee findings. In the committee findings, your lordship, the petitioner was referring to para 3, wherein it is mentioned that there are already 111 numbers of permit issued by the district administration from 1988 till date. Now, in this present writ petition, his petitioner is praying for compensation of this 111 number of permit that we have issued. Your lordship, by document, I will show before my lord that 111 number of permit that was issued by the administrative, is it the handiworks of the government or is there a contribution on the part of the petitioner? In the latter stage of my submission, your lordship. However, since the petition, my learned friend was banging on this, I want to state that 111 numbers of permit that was issued was also because the petitioner has contributed to it. Your lordship.
Petitioner has contributed in a sense?
In a sense, your lordship, a huge portion of the land, petitioner has allotted, sold off to private individuals. Okay. Who then, after came before the district administration, seeking such a permit. And we have issued it.
So this, among these 111.
Yes.
So some of them have been permitted or sold or given by the petitioner.
Yes, not only permitted, but sold at an exorbitant rate.
Okay, thereafter they
came before the district administration.
Being permitted or given by the petitioner, they approached the
district administration for issuing of the permit. Yes.
Okay.
And because that has been sold, we have issued the permit. We have filed documents now, affidavit in opposition, your lordship.
You have filed?
We have filed in the form of an affidavit, your lordship. We have already shown.
Okay.
We have already annexed such documents, your lordship.
Okay. Let us see one.
Your lordship, affidavit in opposition filed in WPC 58 of 2017.
58?
Yes. I would like to take my lordship to page 24, annexure 8 of my affidavit in opposition.
Is this affidavit?
58K of 2017.
58 also page number, yeah.
Yes, we have filed, Your Lordship.
No. It doesn't have page 58.
No, Your Lordship, if in the WPC 58,
Yes, 58, and then page in the affidavit?
page 24.
Okay, 24. Okay.
Now, Your Lordship, this is a survey conducted by the Additional Deputy Commissioner in assistance of Surveyor, Department of Land Revenue, and DBs of Digit.
So this is.
Yes, Your Lordship may come to column 5, serial number 5. The second column, it says sold given to private individuals, organization by Sri L. Nogman Konyat, and permits obtained for the same by the office through the office of the ADC Digit. Your Lordship, 79.912 acres.
So this is special permit.
Yes.
Is this a report or?
Yeah, this is a survey report.
Survey report.
Yes.
Survey report submitted by?
The ADC, which was subsequently submitted to the government. Yes.
So,
a huge chunk, Your Lordship, 79.912 acres of land has been sold, permitted to private individuals and organizations by the petitioner. And the same permit was obtained from the office of the ADC Digit. Your Lordship, if you see column 3,
yes.
serial number 3, it says allotted to private individuals organization by the office of the ADC Digit. It is just 38.0014 acres, much lesser than what the petitioner has sold off and given it to the private individuals. So the numbers of permit that has been issued by the district administration, it is not the handiworks of the district administration alone. For the land, Your Lordship, that he has already been sold off, he is here before this court seeking compensation on that land again, which has already been sold off.
Okay. So this serial number 4.
Yes.
No. 5, 6, 7.
Yes.
76.912 acres.
Yes.
17.548
Yes.
acres.
This also has been sold off by the petitioner, but no permit has been allotted from the government.
Okay. So this you are talking about is 76.912.
Yes.
Was permit.
Was sold by the petitioner to private individuals, organization.
This is with regards to 111.
Correct, Your Lordship. So 111 includes those persons.
Okay. Okay.
Lordship.
So this was this report was submitted pursuant to what order?
Your Lordship, if you see, Your Lordship, it starts with in reference to the Home Department.
Home Department.
Yes, in reference to the Home Department, letter dated 27th of January 2020, and as directed by the authority, survey was conducted on 31 January 2022 with the assistance. But Your Lordship, I'll come to this particular page, if I may be allowed to refer it later on, Your Lordship.
Yes.
Now, Your Lordship, this inquiry report was duly submitted to the government. Yes.
Let us see the last remarks
Lordship,
in that report. The total area claimed by so and so petitioner
yes.
to arrive it with out of court settlement. What is this out of court settlement?
But before that, Your Lordship,
Yes,
page 57.
57 or
57 of the writ petition, Your Lordship. Allow me to finish this particular report, Your Lordship.
yes.
Page 57 of this.
Yes.
Of the writ petition 88, my Lord.
Yes.
Now it says, Your Lordship, the report says, on physical verification, it is found that the district administration during various tenures of which have issued 11 notes of permit from 1988 till date. During inquiry, it is also found that the complainant Sri Nokman, on his own capacity, has been selling all plots of land to private individuals as a substantial rate without the consent and information of the government. On further inquiry, it is also found that the vast tracts of land has already been allotted, given away free of cost to several private individuals on several locations. It has also been revealed that Sri Nokman taken full advantage of the privilege given by the government to his father for a farm land, has sold out 12 plots, to 12 identified individuals by taking substantial amount of money and later permit acquired by this donee from the ADC office digit. So there are various, Your Lordship, allotment done, given, sold. It is all recorded here, Your Lordship. Now thereafter, Your Lordship, the inquiry report was duly submitted to the government.
Yes.
And the government, Your Lordship, has by an order dated 24/9/2018 has cancelled the special permit allotted to the petitioner's father. Your Lordship, the cancellation order is at page 80, annexure P of the writ petition.
Yes.
If I may be allowed to read, my lord.
Yes, please.
In order dated 24 September 2018,
Yes.
in pursuance to the letter from the Home Department, Government of Nagaland, via letter number such and such dated 14th of September 2017, with regards to special inquiry report on the special permit issued to late Wanshu Konyak for farmland at Tijit headquarters. The permit number such and such dated 29/3/1971 is hereby cancelled with immediate effect in view of the expansion and development of Tijit administrative headquarters, requiring all the vacant land for public office establishment. Your Lordship, I would like to make one submission here. In the order, cancellation order, a sentence is clearly mentioned, that is, it is hereby cancelled with immediate effect in view of expansion and development of Tijit administrative headquarters, requiring all vacant land for public office establishment. So, Your Lordship, now it goes back to my first submission. Why was the land donated by the Jaboka villagers to the government? Is it not for the establishment of the Tijit headquarters?
So you have the records of these villagers donating their land to the government when it was made.
Lordship, not only the inquiry court, but the Jaboka villagers themselves have submitted a representation to the government expressing the resentment of huge amount of the huge plot of land allotted to the petitioner's father. I have annexed it in my.
When this objection was made?
Your Lordship, during the time of the inquiry.
Okay, this is during the time of the, not at the time of the giving. It was in the year
71.
71. So they have made objection in the year 2022.
Lordship, no, not in the year
2020.
Two 2014.
14. On what occasion?
Your Lordship, it says at page 24 of my affidavit.
Okay.
File in WPC 88, Your Lordship.
58.
Yes, my lord.
58.
88. File in WPC 88.
In 88 also you have filed affidavit.
Yes, Your Lordship, I filed. Page 24, my lord.
Page 24. Yes.
May I read, my lord?
Yes.
To the additional Deputy Commissioner, Tijit Mond, subject. This is dated 25th September 2014, Your Lordship.
Yes.
Just above the subject. Yes. Subject, lodging of complaint against allotment of special permit for a paddy farming within 1,200 acres of Tijit town to Sri late L. Wanshu Konyak. Sir, with reference to the subject indicated above, we the undersigned, Jaboka village councils and dignitaries would like to draw your kind attention towards the aforesaid complaint being lodged to your competent authority for your kind redressal pleased. That, sir, the Jaboka village has donated, free of cost, a land measuring 1,200 acres for Tijit town development to the government of Nagaland for the well-being of all. However, it is learned that the surplus of the land has been occupied and is under the ownership of one Sri L. Nogman Wanshu, son of late L. Wanshu, with a special permit being issued by the concerned authority. Henceforth, taking this matter very seriously, we strongly condemn and put an objection against hoarding of land by an individuals within this donated land by the Jaboka villagers. This is for your kind information and necessary action, please. Now, this issue that the land was donated to the government is not disputed by the petitioner at all. The petitioner also is not refuting that the plot of land that was given to the petitioner or permitted to his father for cultivation purpose also falls within this particular plot of land that was donated by the Jaboka villagers. They are also not refuting to that. Meaning thereby, Your Lordship, this is an admitted fact that the land originally belongs to the Jaboka villagers, which was subsequently donated to the government, and thereafter a special permit was issued. Lordship. And therefore, the order dated 24 September 2018 was issued by the government, cancelling the permit, special permit that was given to the petitioner for the purpose of development of digit administrative headquarters.
So this was issued without giving any notice.
No, Your Lordship. It was done as per the special inquiry report, which the petitioner is already aware of it. And not only that, Your Lordship, if you see the bottom column, copy 2, the name of the petitioners can be seen as serial number 2. Now thereafter, Your Lordship, what happened was, the petitioner thereafter submitted representations to the government. To arrive at out-of-court settlement.
Please.
Your Lordship will find that my affidavit in opposition survey report, in the survey report.
Okay.
Why was this survey conducted, Your Lordship? It was because the petitioner has submitted applications seeking for out-of-court settlement with certain conditions.
Okay.
With certain conditions, Your Lordship. Now, Your Lordship, if you peruse this survey report.
Just a minute. Huh?
Yes.
So this
It's already for.
okay. Yes.
Lordship, it's already for. Shall I continue, madam?
So we can continue tomorrow or day after tomorrow. So when? But this will finish
tomorrow, Your Lordship.
Tomorrow, I may be. I have.
Day after tomorrow. This week.
No, Your Lordship.
I'm here for 3 weeks.
Yes.
But within these 2 or 3 weeks, we'll have to finish it.
We can continue. Yes, it is. It is.
So, so private respondent also need to submit.
Yes.
So when do you want? When can we fix?
Day after.
Oh, Your Lordship, yes, day after there's a division bench, and Your Lordship,
Yes.
Friday being an election day.
Oh,
Lordship,
yes.
I have some difficulties on Thursday. I'm really sorry.
Next Monday. Next Monday. Next Monday or Tuesday?
When you do.
Next week any day.
Tomorrow I have a program at the college. Yes.
Next week any day.
You fix a day. 20th. No, it cannot.
Next week, any date. I'm Your Lordship. I'm here also.
Okay. Any convenient date. You just decide and tell me.
Wednesday.
We'll have to, because now since we have started.
Yes.
This Wednesday.
So next week when can you come?
Your Lordship, whether the division bench will be.
So
after the division bench, whether we can the single bench will be sitting or not.
It is always safer in the single bench. No?
Yes.
So
Thursday.
when are you available? Okay. Just a minute. Mr. Pongner,
yes.
Staff. Also had Mr. Enangame. Then is Shena Government Advocate for the state respondent, and Miss
He may not be there. No?
Apila Lanet Council for the respondent number 6.
I'm coming.
One, two, no, he's there. Lordship, I think Your Lordship will be available up to 29th of.
Yes.
We can take
3 weeks, I'm there. Yes. So this is in 88, huh? 88, huh? WPC 88, huh? Okay. So earlier order also should be in WPC 88. Earlier there was an order. It was typed by Chelsea. This should be in the 88 also, huh? Okay. We are on 88, I think.
Yes, yes.
Yeah. So, hard in part. List the matter on
29, Monday.
29, Your Lordship?
29?
Yes,
Why in the last?
because Your Lordship, she is not available next week.
Lordship, I have the fixed matter of station, Lordship.
Out of session?
Lordship.
So, yeah, so how much time you'll take? How much more? No.
Another 1 hour more.
1 hour.
Yes.
Then what we can do is we can fix 1 day for his argument and then 29 for you. That can be done?
Your Lordship, it is okay?
Or what?
Yes, yes. If Your
So because in the last date, we can't depend on the last date. Last date, 29.
29 is the last date for your Lordships.
No.
No.
For the hearing the questions. 3 weeks.
If my Lord is sitting for 3 weeks.
Yes, 29, of course. 29, okay, we can fix.
29 is on Monday,
Yes,
huh?
No problem.
Yes, yes.
No problem.
We still have some more days, yes.
29, huh? Okay. As a part, huh?
I'm deeply obliged, my Lord.
So, this kindly, no? Last time we have missed out because that I could hardly staple it and keep stable for it. Go back to this. Okay.
1 hour বাঁচিলে ভাল লাগিছে তো খতম কৰিব লাগিছিলে